Again, and team ISSR. A very good morning to one and all. I am Kamli Singh, and it's given me an immense pleasure to extend you a warm welcome on behalf of ITMU ISSR, which has clubbed all of us for sensitizing workshop on innovation, access and benefit sharing in intellectual property rights and technology commercialization. Now I invite all dignitaries to please come on the dais and grace the occasion. Once again, we would like to welcome all of you with a big round of applause. Now, I would like to request respected director sir to welcome respected today's chief guest of the event, Dr. J.P. Mr. Sir, former ADG ICR with a bouquet and all. Before the program begins, I request to play an ICR song.
जय जय ऋषि परिषद भारत की सुखद प्रतीक हरित भारत की ऋषि धन पशुधन मानव जीवन दुग्ध संवर्धन वैज्ञानिक विधि नव तकनीक पारिस्थितिकी के संरक्षण भारत की जय जय परिषद भारत की हिम प्रदेश के सागर हर पथ वन शिक्षा शोध प्रसार पकड़ आशा भारत की जय जय कृषि परिषद भारत की जय जय कृषि परिषद भारत की
Now, I would like to request respected director sir, welcome respected today's chief guest of the event, Dr. and all. Thank you very much, sir. Now I would like to request Dr. L.S. Gangwar, sir, to welcome Dr. Siripati Rao Kulkarni, Principal Scientist and Coordinator, IPR's International Relations, CDRI, Lucknow. Thank you very much, sir. Now I would like to request Dr. L.S. Gangwar, sir, to kindly facilitate and welcome Dr. Vikas Bhati, Assistant Professor, Ram Manohar Lohiya Law University. Thank you very much, sir. Now I would like to request Dr. L.S. Gangwar, sir, to kindly welcome and facilitate PC Sugarcane ICR ISSR with a bouquet and song. Thank you very much, sir. At the outset, I would like to request Dr. L.S. Gangwar, sir, in charge ITME, for giving a brief introduction about the workshop.
Thank you, Dr. Kamini. Honorable Director, ISR, Dr. R. Viswanathan, sir. Chief guest, Dr. J.P. Mishra, sir, ex-ADG, IPR, ICR, New Delhi. Guest, Dr. S. Kulkarni, sir, from Dr. Vikas Bhati, sir. Dr. PC, Dr. Dinesh Singh, Dr. A.K. Sharma, sir, in charge, uh, AKMU. So this is again, I welcome all the guests for this one day workshop that is on citizen sensitization workshop on this IPR. And the main thing is that if we have a lot of innovations, and the main aim of this workshop is to sensitize our scientists as well as farmers to have how these innovations that has to be reached to the farmers. And the main thing is that for the innovations, because we are living in the age of IPR, so whatever the innovations we are doing, we have to have a proper, it's IPR, it is intellectual property, and it should be preserved in a proper form. And another thing is that the IPR it is exclusive rights for the inventors, so that we can earn a lot of money, as it will be the its unauthorized use can also be minimized. Another thing is that whatever the technology we are generating, it should reach because we are working to the farmers. So it should be reached to the our ultimate clientele. So this should be also be benefited by that technology. So the timely delivery is also very important. So during this ICAR regime, because it is a new in this ICAR system, right? Last 2007, we are having this ICAR system. But the progress is very, you can say, still in a very minimal stage, or you can say very not up to that level. So we are picking up day by day. So this way we have to, while this workshop, we would like to sensitize our scientific colleagues for how to protect our innovations. So this is a one-day program, and this I also thanks our sponsor. That the program is sponsored by this financial support given by UP Council of Science and Technology. So we also acknowledge because that by this way we have. Thank you very much, and we will have a 4 or 5 lectures for this on IPR. So it will be, I think it will be very fruitful in this. I welcome everyone for this workshop. Thank you very much.
Before the address of our honorable director, sir, I would like to request Dr. A.K. Sharma, sir, to kindly welcome and facilitate our director, sir, with a bouquet and sword. Now I request our honorable director, sir, to kindly give his blessing on this occasion.
Good morning to all, the respected chief guest for this program, Dr. J.P. Mishra, formerly ADG, IPR, ICAR, and our invited resource persons, Dr. I think Dr. Vivek has to come, and Dr. Sripati Rao Kulkarni from CDR in Lucknow, Dr. Vikas Bhati from Ram Manohar India National Law University, our colleagues, Dr. Dinesh Singh, Project Coordinator, Dr. A.K. Sharma, AKMU, Dr. Gangwar, and Program Coordinator, and also is in charge of ITMU, and my dear colleagues and farmers. So, good morning again. So this today's workshop on innovation, access and benefit sharing of IPR and technology commercialization, sponsored by Council of Science and Technology, UP government. So this ICR has started this maybe 20 years before, and this IPR activities with a separate mandate. So each institute in ICR, we created ITMU units, and then continuously we are sensitizing the scientists on at least on the IPR areas. Here, one important thing, and earlier we have not bothered about this IPR. Since from Green Revolution time onwards, almost we have been focusing on improving food production and also developing the technologies. Since then, there have, of course, for nearly 2-3 decades, our focus was on that particular area, and then we have achieved self-sufficiency in food production. And later the focus has shifted. So we have achieved the food production and in various sectors. Now, if you see horticulture crops also, that most production, especially horticulture crop production, has surpassed the food production in the country last 2-3 seasons. So that means is all through these improved varieties and technologies, we have achieved this whatever this progress. But by the same time, and now the every from Niti Aayog and even earlier planning commission, every time when we ask for money, so there is again the question was asked about ICR or SAUs. What is the income you are generating and how best you are selling your technology? On one side, ICR institutes, we are bound to give our technologies free of cost to the farmers. So that's how, on the other side, we have been asked to commercialize. But now this is, we have come to that IPR regime. So there, now this issue is very clear, and especially with the private sector is playing a very big role in the seed industry. Of course, the sugarcane crop where it is still almost 100% it is a public sector contribution is there. So farmers are not having any pinch of it's an issue on this IPR issue as far as the variety is concerned. So our varieties are whatever the varieties which we are developing, it is directly going to the beneficiaries. So whatever the farmers are reaping the benefit from sugarcane varieties, they don't need to have any extra pie as in the case of other crops, especially the vegetable crops or cotton or other maize, where the private sector is dominating. And close to 90% of seed industry, especially in these crops, is dominated by the private sector. But whereas in our case, 100%. But now we have come above the thing, apart from varieties, especially IASR, where we have developed so many technologies. Not one, so especially in the machineries. Several machineries have been developed and commercialized at our institute. And similarly, other technologies, either in case of jaggery related or plant protection related. So, but now we are also, we are being asked by this ITME unit in Delhi that we have to commercialize our saleable technologies so that this technology will reach the farmers through, yeah, maybe the intermediaries through the business people or the industrial groups. So that's how now our so that is also giving some focus on for us also how when we take up a research project, how where what would be the commercially viable technologies which we will bring out. So in this regard, our Director General also emphasizing on one scientist, one product. So that means we have to come out with a product. It may be a product and this is not directly relevant to farmers also, but it will have a commercial value. So that these are the areas now already, now this year regime, especially last 2 years, we must be hearing more on the things. And especially on this area, particularly OD, that one scientist, one product. Or it is, this is the area where we have to come out with the new technologies that will go for a commercialization or at least some given ICAR technology certification also. Now institute ranking also being you must be knowing now recently we have submitted documents for ranking of our institute. Again, these certificate technologies are making that is contributing a major chunk. So that means either patent or certificate technologies or CBS release varieties. Like that, these parameters are taken into account. So that way we have to focus on these areas. And coming to this workshop, where Dr. Gangwar has taken this initiative to get funds from UP government for the sensitizing this area. And this particularly, we have also invited the farmers. And there is with this workshop, we have three eminent scientists who are working in this area. And apart from that, we have Dr. J.P. Misra, and well known that who is probably one of the founders of this area of work in ICAR. So we would like to hear from them, and I hope this program will have lots of positive impact on our attitude also and in our project formulation also. And this outcome will be, I am looking forward very positive outlook of, about this workshop. And I thank every one of you for making this program a successful one. And thank you again. Another expert has come. Okay, okay. Okay, Dr. Vivek, welcome to, thank you.
I would like to request Dr. A.K. Sharma sir to kindly welcome and facilitate Dr. Vivek Srivastav sir with a bouquet and shawl. Thank you very much, sir. It's our honor to have with us Dr. J.P. Misra, sir, former ADG IPR ICAR, at present Chief Executive Officer, Intellectual Property Management Center, GB Pant, University of Agriculture and Technology, Pantnagar. Now, I would like to request respected Dr. J.P. Misra, sir, to kindly deliver his talk on topic towards intellectual property rights and enlightening us with his thorough experience and vast storehouse of knowledge. Please welcome to the sir with a big round of applause.
Good morning, all of you. Honorable Director, Dr. Vishwanathan, the dignitaries and the guide, Mr. Srivastava, Dr. Karani, Dinesh, Dr. Sharma, Dr. Gangwar, distinguished faculty members, scientists of this institute, farmers, invited farmers. It's very delighting for me to be here this morning. And I feel this is the first time I'm coming to the IIC, sir. I have been here for a couple of times earlier also, but not on IPR. The subject matter of intellectual property rights is now taking shape here. It's very heartening for me particularly, for various reasons. I will not take much time. I just wanted to give you a brief understanding as to how this intellectual property rights came to us. And briefly, how I got involved. That will be brief introduction, and thereafter I will go into some of the details and the importance of this. It all started in 1980s. At that time, in mid-1980s, a special trend was taking place in the world trade. For monitoring world trade, there was an organization known as the GATT, General Agreement on Trade and Tariff. And GATT was monitoring the trade system, trade trends. And there was a very concerning trend taking place in the world trade. Rather than growth in trade, the trade was declining, world trade was declining. And that was worrisome for all the members of the country. India was also a signatory to GATT. So in India also this kind of papers by economists used to come. But then there was a concern because trade is very important social good. Without trade, there won't be distribution of incomes. Without trade, there can't be many participants in the economy. So trade is a great facilitator for employment, for income generation, for income distribution. And this was a concern that world trade is declining, how will the growth take place? The analysis was done and it was found out that the main reason for decline in world trade was subsidies to agriculture. Agriculture in the United States and prior to that in the European countries, England, Holland, all countries, it was being subsidized heavily. And so much so that the government would procure agricultural commodities at prices higher than the international prices. In many situations, when the international prices were low, the government had to really buy and store it and dump it at either at sea or store it in the place. So much so that Europe became known as a region for lakes of milk and mountains of butter. That was the problem of government involvement in subsidizing agriculture in the mid-80s. That was an outcome of the subsidy element in agriculture in European countries and United States in the decades of 1960s and 70s. People started thinking about what should be done. And then they came up with a proposal, which in India in mid-80s was known as Dunkel proposals. I don't know whether you remember Dunkel. Does anyone remember Dunkel? I'm not surprised. He was Director General of General Agreement on Trade and Tariff. When Dunkel proposals came in mid-80s, after the Uruguay round of talks, then there used to be a lot of demonstrations against it. They would say that no, this proposal has come to bring it, this is an invitation to another East India company. India will again become a slave country. It will be earlier East India company took control of India. Now some other company will come and take control of India. Now that was the kind of apprehension which was taking place. And anywhere, demonstrations in Bangalore, Hyderabad, other places, it was taking place. And there were articles also, prominently one by Dr. Devendra Sharma, Suman Sahar, Vandana Shiva, and many others, even including Dr. Swaminathan. He did not write against it. He saw some opportunities in it, which I'll come later. But then this is how this whole thing started. The Dunkel proposals or World Trade Agreement proposal, it comprised of 22 documents. And the documents comprising agreements and also ministerial declarations. So in the agreements, there is an agreement on agriculture, which I read as a student of economics. I read with keen interest. And it talked of aggregate measure of export, market access, and export competition, 3 areas. So And thereafter, there was another proposal known as sanitary and phytosanitary measure. That was an agreement. There was another agreement related to trade-related aspects of intellectual property rights and trade in counterfeit goods. That was known as TRIPS agreement. This agreement aroused a lot of apprehensions in the minds of the Indian people. They said that, they will bring a patenting system, a trademark system, things like that. And then we'll become again in the grips of, we'll come into the clutches of the West. What happened at that time? At that period only, in the late 1980s, some patents came to the news. There was a patent on haldi taken in the United States. But there was a patent on neem. This again aroused suspicion in the minds of the people. Then there was a patent on basmati rice. This was a bombshell. And then there was a patent on wheat variety, Napal. You see, these 4-5 patents, 3-4 patents, they really created agitation everywhere. Our basmati is going away, our wheat variety, Napal will be taken away. So there used to be huge and cry about it. I, as a student in this economics and as in charge of financing high-tech agriculture in State Bank of India, also started reading it. And somehow I got interested in it, and then I used to consult people because the writers were generally from Bombay, Delhi, and other. So I talked to them, and I found that they also had very sketchy knowledge. People did not go deep into the matter, yet their voices were very important. So I also started taking interest, gradually patenting system and other. And then I found that although you are writing about it, they are only making a noise. Some work should be done definitely. I came across a book on the Indian Council of Agricultural Research, which gave all the network of ICAR. And out of some sheer curiosity, I wrote a paper, Intellectual Property Opportunities in ICR System. Somehow, that paper went to the hands of Dr. Baroda, and he said, I want this man in ICR. That's how I came to ICR. This is a brief way of entering here. But then I imagined, after looking at the literature, review of literature and all that, that Indian Council of Agricultural Research is a real powerhouse for generating intellectual property in the country. That was my claim. And I came to ICR, and then I was very fortunate to have face-to-face discussion with the leading crusader on intellectual property right, Dr. R.A. Mashelkar from CSIR, whose institutes representatives, they are here as a dignitary speakers, we will be listening to them. I had opportunities of course interacting with Dr. M.S. Swaminathan because he was a fatherly figure for us. To me, he was a director when I was a student at IRI, and later on for all of us, he was, because he was the knowledge source for various areas, and IPR was one. Because in one of his articles he had written that most of the foreign experts who come here, they used to take away seeds of paddy and wheat in their shoes and hide it, so that they could take it and use it as a germ for the material for developing new variety. That was his observation back in 16 when Green Revolution was making a beginning. So he was a keen observer, and he of course noticed that there is a lot of strength in intellectual property area, and India should dump and take the lead in it, part in it. So that's how I got involved in it. So, and the another thing was that I have been a student of economics, and I found that the developments all over the world is outcome of the imagination of leaders of the country. The development in the sense, I came across a speech by protection. There was adequate protection to inventors. There was adequate protection and remuneration to the innovators, and at the same time, there is protection from copying. Stiff laws were passed to punish anyone who is taking time, who is trying to copy patent. So that is how patent became a very powerful source of intellectual property. And patent even today continues to be the most important what you call area of intellectual property protection. So these are some of the developments I wanted to share with you before I would embark on this subject. The TRIPS agreement, and we say legal arrangement in every country for protection of intellectual property rights. These areas were, first was the copyright and related rights, second was trademark, third was geographical indications, fourth was industrial designs, fifth was patent, sixth was layout designs of integrated circuits, and seventh was protection of undisclosed information. These are the 7 intellectual property rights on which the TRIPS agreement envisages. And most of the people, and you must be knowing also these rights are well known to people. But then they came up that there has to be, in the legal system, there has to be some arrangement for adequate protection. Now, it's not that these intellectual property rights were not known to us. At least 3-4 laws were already in place. We have had a right, what you call a law legal system for protection of designs. Designs Act was passed in 1911. Then Trademark Act had been passed in 1940. Then we had a Patent Act which was passed in 1970, and then copyright we had in 1957. Like that, these four intellectual property rights are already there. But then, unfortunately, and we have got an expert from Law University, the lawyers also never bothered about it because there was not much demand for it in our country. In the search of out of curiosity, I visited offices of patent offices in Bombay, Delhi, 2 places I visited, and they were really got for second places. Hardly 1 or 2 persons would be around in a very what we call useless area. I mean, they didn't have any arrangement for office and things like that because we have only a legal system, but we didn't have enough network, we didn't enough bureaucratic arrangement for those things. So, but then it's the TRIPS agreement and we say that you have to have an adequate legal system of protection. For that, you have, for example, copyright and for a trademark. Now these options, the rights were the various ministries were responsible for it. For copyright, you have to go to Ministry of Human Resource Development. For trademark, you have to go to Ministry of Commerce. Like that. So this was all in the area of like separate control. There was no unified control, there is no uniform policy. So these things were there, these anomalies were there in our system. So they said that you have to have a proper system of protection, and then you have to bring reforms in the existing laws also. Now I will not touch all those things or various laws. Briefly, I can tell you about all these, but that will take a lot of time. I don't know how much time I have. Time. Okay, thank you. So let us concentrate on patents because we have, of course, we have made many changes. One important act was passed out that the outcome of the TRIPS agreement was Plant Variety Protection Act. This was a major thing for the protection of farmers, and Dr. Swaminathan and scientists of ICR, they played a great role in this kind of arrangement. Then we have got a brand new act for semiconductor for protection of layout designs of integrated circuits. So these new laws came up. Now, I will come to exclusively patent. What is patent? Patent is very easy to understand. Patent is when there's some idea which is new, it is not an inventive step, and is capable of industrial production. When it is injected into some object, then it becomes a patent. You may have some idea, and then you transfer this idea into an object which can be sold, and the object can be again multiplied, it will be produced commercially. Now that is patent. So there were three things. The idea has to be new, the idea must involve inventive step, and then it should be capable of industrial production. Very easy. And says patent rights should be available for the product and processes, both. It's not only for product, even the process which is used for the that is patent is available for processes also. So well, product should be available for patent product and processes, and then it should be for a minimum period of 20 years. Now this is what they said, because in our country we have a system of protection through patents by granting period of protection for a period of only 7 years. Now 7 years was too short a period at that time. And in soil minutes you can't do. You move an application, it gets granted in 3-4 years, and thereafter only 3 years are left. Which industries will come to buy this? Nobody will come. So, and then they also found that most of the important areas in which research could take place and useful objects could be prepared, like food, drugs, and medicine. In these areas, considerable inventions take place. But in our Indian patenting system, this was not patentable in section 3.5. So they said that no, this should be also made applicable to it. They also said that products and processes related to plants and animals, we can exclude them. But the processes which involve biological processes or non and microbial processes, they should also be protected. So, it's microbiological processes that should also be protected, which means that the new system of protection enlarge the scope for protection. Massive scope, which will come later. Because earlier the life forms were not patented. In 1980, one Indian scientist who was working in an American company somewhere, Dr. Anand Chakrabarti, he came up with a bacteria known as Pseudomonas, which had, and he had developed two plasmids in it. Both the plasmids were effectively generating energy to degrade hydrocarbons. That means in anywhere where oil spills used to take place, if you release this bacteria, then it will be able to clean the entire water. Now that kind of innovation, which that research when it was applied for patent, the patent was granted. The American Supreme Court allowed this. That no, this type of life form to be patented. And you see, this has opened a floodgate for the opportunities for the scientists who are doing work in the area of microbiology, biotechnology, biochemistry, and other areas. So that means this TRIPS agreement gave us an opportunity that we can involve our scientific law. We have got all these scientists who can work in this area, and therefore this became very particular. This is an opportunity. This is the way I see this. Now, having said that, I will say that it has enhanced the scope of protection. We have never, after several modifications, we have come to know good patenting law in our country, and India is making good progress in it. Now, at this stage, I would like to talk about the benefit sharing opportunities. ICR came up with all these commercialization technologies in 2006, 2007. Good useful book came up in 2007. And various items, various aspects have been discussed at length. How should you price the technology? What should be the share of the scientists? How should it be channelized between ICR, institute and with the scientists down the line? All these things are there. I will not say much about it because it's on the part of ICR people. I presume that it is known. But then commercialization still remains a challenge. Dr. Gangawar recently went, I'm told, and he said he found, I talked to him and he was telling that IPRs are there, patents are there, but there are no takers. Now, there could be two reasons. One is that ICR develops items which are readily usable to farmers, the varieties. I also fully agree that these varieties have been developed by the government fund for the benefit of the farmers. So there is no point in what you call trying to take benefit out of it, and scientists should not be punished for that. So one product, one scientist, that slogan will definitely yield result, but then and scientists should not be penalized that he has not been able to earn money for it. But in the area of patents, there are opportunities, and that opportunity must be utilized, to the fullest extent. But then how do we utilize? I also find in Pantnagar I filed about patents for 60 applications, 60 events. Very little takers. There was one scientist who developed a variety, who found out a fungus which eats plastics. The patent was not granted not only in India, it was granted in the United States also. It's a great patent by Dr. Rita Goel. She was head of Department of Microbiology. We discussed at that time the Dr. Mangala Rai was formerly DG of ICR. We all discussed and we thought that this technology must fetch something like 500 crore rupees. That was our estimate. The Vice Chancellor agreed for making it to public known. You have to go to the press, advertise it. The advertising cost minimum was 2.5 lakh rupees. So he granted, he sanctioned that amount. And we went to the press, released it in Economic Times, Hindustan Times, Calcutta edition, and all that. There were only two applicants, two interested buyers in that for that fungus. That means the mindset for purchasing Indian goods of the Indian capitalists is very fixed. They are not interested in buying anything developed in India. That is what appeared to us. That people do not want to buy things which have been developed here. Those who have money. And the other thing which forces me is to understand the demand. The demand, production of a commodity is one thing, but demand for a commodity is another thing. The demand can be understood variously by various type of people. We eat rice, wheat, all these things, and we know that it is in demand. But then there are people who are in trade of this thing, and they know in which area there is a demand for which thing. For example, rice varieties I am giving. In Tarai area, there are a lot of farmers varieties. There is one variety known as Tilakchan. And I know a seed plant owner, rice plant owner, and he says, Mishra ji, Tilakchan की variety मिल जाएगी क्या? He talked to me for the last 4 years. He has been asking me this, and then that compelled me to think that this man knows that there is a demand for Tilakchan. If Tilakchan is not available, but it is really liked by some people. There are some people who are prepared to pay a lot of money for Tilakchan. So the understanding about demand will come from the producers. The producers of the rice, not producers of grain, gram, paddy. Those who are the trade of rice, they will know the demand for it. So assessment of demand is the most challenging aspect of the commercialization of technical property. If you do not have Intell, you just come and display in your workshop here, that will probably, at a limited person, that I'm afraid it will not work. So what is needed is that you have to find out the demand as to where it exists and who are the person who will be able to channelize. So I think it calls for in-depth analysis and a network and a proposal for channelizing, your product to right area and the right pathway for what you call channelizing your intellectual property. If you just come up with a whole cafeteria of intellectual properties before you can run the platform, then there has to be big mega for it. And that doesn't work often. That's my assessment and my experience. It's a very challenging task. And I only wish luck to ICR scientists, whether they will be able to come up with the share of it, unless they are supported. What I think to my mind, some things generally which come to my mind is that just as you subsidize production, just you incentivize scientists to do research, you also incentivize those who buy the technologies from scientists. If we do not find those people and we don't incentivize them, then probably this will only result in a mere slogan and it may not really yield results. So this is one thing I wanted to share about the commercialization. I have found that it is the most challenging area now. We have come a long way from where we were in the area of IPR, from a very rudimentary state of production. We have come to a very sophisticated state of production, be it in the area of patent, be it in the area of trademark, be it in the area of geographical indication or patenting. But we have to think of fresh and new ground have to be broken for bringing it to what you call to some satisfactory situation. These are some of the things which I thought I would speak, and I think here I will stop, and also would like to have any questions if you have. Thank you. Well, if there are no questions,
So what is that? What if our some publication has come out and technology already manufactured? Then can we file patent or we should go for the design?
no, it's a publication. If it's published, then it has to be protected first. There are many, I have come across one situation where some scientist guided a messy student. And then he filed an application for patent, he filed it. And then patent office said that no, it is already published material. And the published material is that the thesis, whatever thesis is written by scientists or students, it goes to the library. And the moment it goes to library, it is a part of public domain. So it becomes ineligible for protection. But still, if you have gone for commercialization, very good. Go ahead. Because the need is for commercialization. If you have not been able to patent and yet you have commercialized, it's good. It is clear.
So the second question is that if patent has been filed, number has been allotted, whether again after that we can publish the paper?
Yeah, you can do it. You can, after it has been filed, you can publish it. If it has been published by patent office, the abstract is published.
Yeah.
After publication, you can go for commercialization.
And again, sir, yeah, that paper has been published.
Yeah.
Whether we can go for design patent?
You can go for design patent, but what is the use? Who will buy the design? It is only for increasing the number of patents. Any other, I'm very early, I found some interested person and interesting questions are coming. Because patenting system involves writing of a document which is known as a complete specification. Let me also give it for your benefit. It requires three major things. One is you have to write preamble for your patent. Second, you have to write description. And third is the claims. Now, preamble is similar to the review of literature which every MSc student writes. The only difference is that in the review of literature, you need not give details of patents filed earlier. In preamble, if some patents have been filed in that area, whether in US, China, there are 5, 6 countries. If it has been published, then that also should be mentioned. And the purpose of writing a review of literature in thesis is to prove to reader that look, this work has been done, but there are so many deficiencies in it. That is why review of literature is written. So when you write that review of literature or preamble, it develops automatically a force for laying a claim on your work. And then you have to describe description. What are the steps involved? Step 1, 2, 3, 4, like that. And there your evidence of inventive step will come. Now, most of the applications face this music from the patent office. And what is the inventive step in your work? Now you have to prove that inventive step, which is the inventive step you have taken. Now, how is inventive step proven? I will tell you, sometimes a judge has said that sometimes when an existing technology is used in a new thing, new item, that becomes inventive step. For example, you know how to develop a nano vehicle delivery system for mining a particular protein, right? With that, for example, omega fatty acid 3 is available from this linseed. If you similarly, recently in Pantnagar, we have found out filed a patent for extracting proline from tambur, this foxtail millet, and then developing a nutraceutical using nano delivery system. Now, the same method can be used for extracting omega fatty acid 3, omega 3 from linseed. So you know, this existing technology can be used. Sometimes people want that something should be done. For example, you have got an inverter, and an inverter has a battery. Now, battery has a life of 1 year or so, 2 years. Now, most of the people want that the battery of the inverter should last at least for 4 years, 5 years, like that. Now, if you come up with a device to enhance the life of battery, that will be patentable. Sometimes people know the way that this can be done, but they do not know how to do it. So that solution will become an inventive step. Now, these are the finally nitty-gritty aspects of, you know, the patenting system invention. So you write in description part, you write about this inventive steps which you have taken, and then you write claims. And claims should embody your whole approach in one sentence, and then you claim that this is new. Now, in patenting system, the courts, the battles are fought for claims, and you have to refute the claims. For example, I remember in basmati rice, the one claim was that the duration of ripening of this particular variety, basmati, is from 82 days to 120 days, or 130 days, like that. This was claim number 5. And India fought against this, and the patent was revoked. So because we showed some results, but we had already trials this under active, when we found result, there was a variation, and this variation is very much within the range of what has been claimed. That means there was existing knowledge. So you have pirated, you have claimed our variety. So these are the three aspects of complete specification. And complete specification, there should be good knowledge about it. Scientists should be taught as to how to write patent. This is the writing part of it. The rest of it, form number one is application, form number two is specification that I have discussed. Three is for when you apply for, in a foreign country. Form number five is for where the declaration by inventors, because each inventor, his name is there in the patent application. So his name, he should assign the right. If some scientist from IISR is making an application for patent, then the director or anybody working on the behalf of director, he should obtain a declaration from the scientist that he has assigned the right to the director to do this work. So that assignment is necessary, legally necessary. Now, these are the forms which you have to, comply. After filing the application, the process is not over. Your patent number will be granted, and then you can say that you have filed a patent, but then you have to make efforts for publication. Patents are automatically published in a matter of 18 months, but if you want to expedite the application, publication, you have to apply for it. After publication, within 4 years of the period, you have to have it examined by the examiner, for which you have to pay a fee of 4,400 rupees to them, and then it will be examined. After examination, you have to face hearings from the patent court. So this is the process. But then important thing from the scientist point of view is compiling the complete specification. My urge will be to IISR and to other institutes that expertise should be developed in a small little outfit for protection, for filing a patent and processing it. Because at one time I found that this work was being done with some government money. But government money will not come always to the institutes. Government will put stop that I have no money. At that time, the institute should be ready to file on its own. So that kind of capability should be developed. That is just a suggestion. Yes.
Sir, whether the number of claims also affect the patent the patent to be granted?
No, it's number of claims do not affect the claims granting system, but number of claims have to be in such a way that they should not be extraneous. There should be only right number of claims. In India, the number of claims, if you exceed number 10 claims, if you exceed your claims from 10 to 11, that will cost you additional money. So we limit it to only 10 claims. You are trying to save money. But it's not necessary that you have to have 10 claims. If you can write your patent in such a way that only 2 or 3 claims you are satisfied that the newness is established, then that is fine. Right? It is clear. Yeah. So these are the some few things. One more thing. The patenting system, it is, people say international patent. The patenting is a territorial. It is when you file a patent, this application is protectable, your rights are protected in India only. But if you file an international application under patent cooperation treaty, then only when you are filing it in USA or Europe or anywhere, that it will be limited in that country only. It will not be automatically protecting your interest in Korea or South Africa or anywhere. That clarity should be there in the minds of scientists, because scientists want that no, it should be protected in all countries. So that is possible only when you file in those respective countries. Your priority will remain the same. Priority of claims, originalness will remain the same from the date of filing of application in India. So your claim will be there, but then you have to, in order to seek protection in that country, you have to apply for patent in that country. So that is all about our system. I thought I could briefly mention cursorily. I don't know whether I'll be able to justify my time, but I thought that I should stop here. Thank you. Thank you very much.
Thank you very much, sir, for sharing your deep knowledge with us. I hope that all attendees will be highly benefited. It's our privilege to have with us Dr. Vivek Srivastava, Senior Principal Scientist, National Botanical Research Institute, Lucknow. Sir has vast experiences in the field of IPR. I would like to invite Dr. Vivek Srivastava to kindly share his experience on the topic patent system in India and national biodiversity. Please welcome to the sir with a big round of applause.
Good morning to all and thank you. Director ISR, my seniors, my colleagues from CSIR, CDRI, and guests from National Law University, scientists, students, and farmers. What I can make out from attire from Maharashtra. आपकी कैप से पता चल रहा है कि आप महाराष्ट्र से so you must have been welcomed earlier, so you welcome again. So sir has set the tone for discussion and has raised some very pertinent points. I would like to read out some data from Indian Patent Office annual report, which you will find interesting also, and what sir has just said the concern also. So top 10 Indian applicants, this is I'm talking about patents, top 10 Indian applicants in India. First is Council of Scientific and Industrial Research. They have filed 223 patents in 21-22. Then comes DRDO. It has 117. Then L&T Technology Services Limited. They have filed 68 patents. Then comes ICAR. They have also filed 60. They have filed 66, and then it goes on for ICMR, ISRO, Center of Excellence in Wireless Technologies, Solar Active Pharma, and then the last 4 organizations. These, except for L&T, last 4 organizations are from pharma sector. So their number is 11, 10, 9, and 9. So as sir has pointed out, that majorly filers are from public sector organizations. And in engineering, we have L&T, and then rest last 3 places are taken by pharma sector. So that indicates that at least in private also patenting activity is higher in pharma. Then you will be surprised to know that if public sector organization or research organizations are taken top places, among academia and universities, if you see the data, I was surprised to see this. And this data was top filer in 21-22 was Sanskriti University. And even more surprising was that they had filed 703 patent applications. Second is Chandigarh University, and only one academic institution or collectively which has come is Indian Institute of Technology. They are collectively at their filing is taken collectively for all the IITs. It comes 597. Otherwise, we have Sanskrit University, Chandigarh University, Lovely Professional University, Chandigarh Group of Colleges, Galgotia University, Tirthankar Mahavir University, Shobhit University, MIT University, Shulin University, Jan Deemed University, and since I don't have specs with me, GLA University, Mathura. So when I received this message, I was surprised to see that how come private universities are filing so many patents. It's more than 7,000 to 10,000 patents if taken collectively, barring IIT. So what sir has raised a question over or gave his observation regarding commercialization aspect. So that is if I have been to different discussion, part of different discussion and all those. The major issue is not that our science or our scientists or their research has any shortcoming into that. But only thing which I will point out from my experience, I may be wrong because my seniors are sitting there much more experience than me. That any place, we have in academics experts for everything for academics. Even for market, for marketing, for business, for commercialization, we have experts from pure academic background, PhD in some science, some applied area. We don't bother to take anybody on board from IIMs or business management and all that. Why I'm saying so is that when I go through all this and I see, I have discussed in when my colleague is sitting in Dr. Shripad in one such workshop. The biggest question was, what we need to find out or we need to concentrate is the three things which should be taken. This is nothing to do with the topic, which I'm saying, just take a few minutes because sir has raised very important point. So I thought to share my views on it. The three things which are there are the need, want, and demand. Sir has raised very important thing, that is demand. Now there is difference in these three. Now what is need? Need is, if any student wants to share his or her view, is welcome to say. Otherwise, what I understand from need is the basic requirement which, as being a living human being, we had. We need something to eat, we need shelter, we need clothes, we need medicine. So that creates need. We all have need, everyday need. Secondly, then comes what is want. Basic need is hunger. We feel hungry, so that is a need. Then what becomes want? Want is the specific satisfier which you want to curb your hunger. You want to have dal roti or you want to have pizza. You want to have curry or you want to have chicken if you are non-vegetarian. So that is your want. Your need is hunger, your want is a specific type of food. Then what creates demand? If I had to commute from my office or NVRI to ISR, what can be the ways to come over here? The way is I can walk down to this place, I can come by cycling, I can by two-wheeler, I can take lift, I can take taxi from Ola Uber, I can use my own vehicle, I can then also, I will like to come by some BMW or Mercedes. Same way for other need or want, but does create demand for Mercedes. If my friend Shripati or any one of us want to come to office daily by BMW, that is a need to come to office and there is a want for BMW. But does this create demand for BMW? No, because the need, basic requirement, demand, want, specific satisfier for that demand, need can convert in demand only if anybody who has that want has purchasing power. So that is where I think we, while filing patents, now we're not saying doing research, while filing patents should consider that what exactly is demand. There may be need, but there may not be a demand. So companies will come to buy our inventions only because our inventions, whatever price we give to them, they need to invest at least 50 times more. So they want return from it. So unless there is demand, there may be need, there may be want, but there may not be demand for it. So that is, I believe, is one of the reason why commercialization, and as such, worldwide commercialization percentage is only 10% of all the patents filed. And we are doing fairly well in that, at least with CSIR. So that is one point which what sir has raised, the issue of commercialization, which I just wanted to share my views on today. So coming to my topic of discussion with you is, I have slightly changed the title of it. Actually, whenever we participate, either as a participant or as a speaker in workshops, when we are not aware about what other person is going to speak, problem with audience becomes that everyone comes and tells same thing for the patenting and copyright. So I ran this risk in one workshop where I was the last speaker, and everyone else has taught what slides I had. So it became very difficult for me to keep them interested. So I thought to venture into area which is basically a case study kind of thing. For in few slides, I will just try to build up the background of it, which as a scientist and as a farmer, you know better than me. So this is the patenting process and biodiversity act interplay basically, which about which I am going to say a few words in slides. So, whenever we talk about biological diversity, it is needless to mention for our scientists and the students sitting here, or farmers also who have experiences, that it is of immense value for our generation, for coming generation. So we need to protect it. And why so? Because as we hear so frequently the word climate change, climate was always changing. Now only thing is that it is changing negatively and at a very fast pace. So that has impacted on everything that includes biodiversity also. In addition to that, because of anthropogenic activities, human intervention in almost every area of our globe, there is loss of biodiversity. So considering this, in 1988, a discussion is started at different levels on United Nations interministerial conference and all those discussions, which ultimately culminated in a convention in Rio in 1992, which if we recall, was called Earth Summit, in which this convention on biodiversity was promulgated and signed by around 150 or more countries in coming years. And all the purpose is three aspects of it are first is the sustainable use, the use which doesn't destroy it, is to conserve it, and those who have kept it so long since the earth is there, we have to be fair and equitable and sharing the benefits arising of use of this. Second part or aspect of it is around 50 or more articles are there in this convention document. Important things are that it gives sovereignty to the countries over their biological resources. They can make their own laws to protect it. And India in 1994 has ratified this. Now, why it is more important, as we are aware that India is one of the world's 17th mega diverse nation. 17 mega diverse nation account for around 70% of the biodiversity of Earth, and India is one of them. Second fact, which is that though we have only 2.4% of world's land area, it accounts for 7 to 8% of all the recorded species, including plants and animals. And we will accept and appreciate this, that rich biodiversity is very essential for the development of the country. Why? Because it is the basis of agriculture, food, all things enumerated here: fisheries, forest product, non-timber forest, drugs, enzyme varieties, secondary metabolites, fragrance, flavors. Everything comes from the plant source, animal source, and biodiversity is source of it. Since I came to ICAR, I found this very interesting paragraph, so I thought to add, because you know that agriculture is for concentration of small number of varieties. We know that agriculture, we have few, which is not very limited number, where we go for their betterment and all that. But For future improvement in these, we need to have biodiversity whereby we can have, let's say, genes and all those which can be progressed in our varieties. So India has promulgated many laws, 36, at least 36 acts, which protect in one way or the other its environment and biodiversity. And that reflects the concern of government over its protection by enacting these laws. And NGT is the latest of which keeps a watch on any environmental related issues. And one of the important law in this regard is the Biodiversity Act. These are some cases, I think I missed a slide. Okay. So these are some cases which sir has just mentioned in his talk just now. I have just included a brief of it. Sir has just said that in case of neem, there was a company, WR Grace, where they have tried to patent the fungicidal property of neem seed extracts. This is one example where the piracy was attempted, it was opposed, and EPO has revoked it. Second is, of course, the turmeric. This is what everyone who ventures into intellectual property rights area or especially patenting knows about it. This is a case of turmeric in which a patent was filed for seeding properties for two expats from India only. Later on, this was challenged by Government of India, and the responsibility of challenging of it was given to CSIR. They have challenged it successfully. It was revoked, and this was the basis of making of traditional knowledge digital library. So this is yet another case, and then this is a case of US where one gentleman in 1986, Lauren Miller, he obtained a patent for a plant. In India, plant is not patentable. In US, you can get plant patents. So it was used by indigenous tribes for treatment of different kinds of ailments. And he tried to patent it in America, taking the plant to America and zoning it there for those properties which are known. And later on, it was revoked. And I came to know from different literature that later it was reinstated also, but how the herbarium sheets are important, that it was revoked initially on the basis of those herbarium sheets in which it was studied and deposited. But I came to know that it was reinstated also for a couple of years. Then on recent cases of such kind of biopiracy is that India has challenged and foiled the attempt of Colgate-Palmolive for patenting a mouthwash. It is based on the Spica fragrance, which we know as Jaifal, and it was again revoked. Then another is the formulation which was revoked by questioning. It was using the pine bark and all those things. A formulation was made. So these are some examples where we can see that if you are not protecting your biodiversity of things, there are people, there are organizations who will take it away from you and then come back with the products based on this for selling in our country or across the globe. So with that objective of protecting our biodiversity and its conservation and equitable benefit sharing, the Biodiversity Act was enacted in 2002 and rules came in 2004, and which is based on the principles laid down in CBD. And it works at three levels. First is the National Biodiversity Authority, which is situated at Chennai, and which is basically for jurisdiction runs all across the country, and it is a prime body for advising government on different issues of biodiversity, implementing the law of biodiversity in the whole country. Then for every state, it works as a state biodiversity boards. We also have a Uttar Pradesh State Biodiversity Board. And then the most crucial part is the biodiversity management committees, which is at local panchayat level. So I know this number must have increased because I've taken it from the website of National Biodiversity Authority, which is updated quite long back. So this number it shows is around 2,76,688. It is the local bodies from which this biodiversity management committees are made, and their prime responsibility is to make people's biodiversity register, in which they document all the locally available biodiversity with them. Now, in this act, there are several aspects of who can access the biodiversity, who cannot access it, what permission is required, what not required. Since I, as said, that primarily focused on only the intellectual property and that too from the patent point of view. So in the chapter 2, section 6 of Biodiversity Act, it deals with how you can take intellectual property rights, especially patents. For plant variety, I think Gangwar sir will be telling in his last lecture, whereby probably it is exempted from taking permission because PPP, FRA, Farmers' Rights, that act itself is mechanism of benefit sharing. But then even then you have to inform to biodiversity authority. So you cannot take any patent without taking permission from biodiversity authority. That is what is mentioned in section 6 of this act, and you have to take permission before the grant of, and that includes India and abroad both, before the grant of patent. So I will share you one small case over here, which we experienced in this regard, that we had one formulation with us. It was basically trichoderma fusant for some desirable properties. So we took, we applied in India and also applied abroad in few countries, maybe 2 or 3. And before we could apply for this Form 3 and all that, or maybe laxity on our part, you can say, it was granted in those countries. So we were forced to abandon those applications because we had not taken that permission. Then we filed Form 3 and signed ADS agreement and all that. So that is how it works, that you before the sealing, use the word sealing. Now there is no provision of sealing of patents. Earlier there was that it was a seal was put on every patent which was granted. So now that sealing has not been, but before grant of the patent, you have to take permission from biodiversity authority. Now, the other aspect that is intellectual property rights, as sir has explained already about the intellectual property rights, these are all the intellectual property. Intellectual property is basically that property which is abstract. So not tangible. You cannot feel it or touch it. So to give protection, the laws, different laws, as sir has also mentioned, are there in India to give protection. And there is one line which is said in patent office earlier envelope also, that was औद्योगिक विकास के लिए पेटेंट एकस्व का प्रयोग करें. Patent is called एकस्व in Hindi. So if it is a award for inventor, it must be reward for the investor. So that is one. So different IPR laws in India for covering different aspects. As I said, there's a Copyright Act, Design Act, Geographical Indication Act, Plant Variety Protection, Farmers' Rights Act, and patent, semiconductor, different kinds of acts. So biodiversity related issues primarily we handle in the patent case. For those cases, as just now, sir has informed about patents, the simplest way which I remember what patent is that it is an exclusive right for an invention given by the government to the inventor or his assignee for a limited period of time in exchange or complete disclosure of invention within the country of grant. So these are the features of a patent that, can you go back? That it is an exclusive right. You can exclude others from using your invention. Also, I like to tell that it is a negative right. You can exclude others from using your invention, but that doesn't entitle you to use your invention. And what does it mean is that even if you have a patent granted with you, you cannot practice if there are other laws from which you have to take permission. You have made a drug, my friend Dr. Kulkarni will tell, if you have made a drug and you get a patent, you cannot practice just because you have a patent. You have to take other permission from Drug Control of India or whatever mentioned in Drug and Cosmetic Act. So basically, it is a negative right. You can exclude others from using it. It is given for an invention, and as it is a law, it is given by the government. It is given to inventors if they are applicant. In India, in USA, every inventor is also an applicant. Here if we are working for ICAR or CSIR, we have to assign our invention to our employer. It is given for a limited period of time. The limited period of time presently is 20 years from the date of filing, not from the date of grant. And the objective of patenting system, one basic is that you disclose your invention to everyone so that for the furtherance of science, for the benefit of humanity, that you do not keep it with you only. So you have to disclose completely your invention in your specification. And in exchange of that, government gives you monopoly right for period of 20 years. And again, it is a territorial right, as I said, that it is applicable only in the country of grant. So if any patent filed in USA, not filed in India, you are theoretically at least free to use it in India without paying anything to that applicant or owner. Next, please. So coming to the interplay of Biodiversity Authority Act or BD Act and Indian Patent Act, Indian Patent Act was amended and in section 10, you have to disclose in your specification if you are using biological material, you have to completely disclose what that biological material is, where from you have taken, or if there is any depository in which you have deposited it. And you also sign in your form 1, where as an inventor you sign, as an applicant, in your case, I believe ICAR must have some centralized system of filing. At CSIR, we have Innovation Protection Unit at Delhi. They are the scientists who are authorized to sign, they sign. And there you have to disclose that you have used biological material in the form 1, and in form 2, that is specification, you have to, under section 10, you have to disclose what that biological material is. So if you have disclosed it, now you have to take permission from Biodiversity Authority of India. How to do that? For that, you have to apply in Form 3. And Form 3 is described in Biodiversity Rule, section 18, whereby I have typed over here is any person desirous of applying patent will have to apply in Form 3. There are 2 or 3 other forms also, Form 1, Form 2, Form 4, in addition to this Form 3, but they are for different purpose. Accessing the biodiversity for commercial purpose or sharing of your research or collaborative research or transfer of research. So in case if you are desirous to have patent application using biological material, you have to apply to biodiversity for permission in Form 3. Next, please. Whereby you have to give all these details. There are a couple of more which I missed, and as you can read it out, that you have to show all the details of your organization or yourself, what invention on which you are seeking IPR, what are the biological resources you are using, the geographical area from which you have taken any traditional knowledge associated with, and along with those documentary documents also, where this activity has carried out, like if anything is going at ISR, you can write it as an ISR. What are the benefits coming out of it? So in this form, along with ₹500 fees, you will apply. You can apply online also. And anybody, there is another form also where institute's director will authorize someone, or he himself will sign on behalf of institute for this Form 3. Next. So of that Rule 18, the other para, that after due appraisal of the whatever information you have given, authority, if satisfied, will allow you for the IPR. And this permission is in the form of an agreement, an access benefit sharing agreement, which you will have to sign with NBA for getting the permission or approval for using biological material in your invention. Next. So this is the flow chart I have taken from the Biodiversity Authority site only, whatever I have said, that you apply in Form 3 to NBA, then after internal process, if you get the clearance, it goes to you, and then you also have to sign ABS, and all those 500 rupees fee or whatever you have signed in ABS, the money which you will share as per the ABS agreement goes to National Biodiversity Authority Fund, from where it will be distributed to the beneficiaries. Next. So it's on its site, NBA has mentioned one case where one Dr. Geeta Pawar, an Ayurvedic doctor from Pune, and she has made some formulation for giving initial kind of first aid kind of thing, where relief from snake bite. So they have mentioned in our site that this is the one case so far the site was updated where a biodiversity authority has given permission and got benefited from the sharing of royalty and license fee. But I will now, coming to our experience at National Botanical Research Institute, we also have shared in 3 patents. We have signed around 50 odd ABS for seeking permission, because our mostly, rather 99.99% inventions are based on biodiversity or biological material. So in almost every case, we have to submit Form 3 of the VD Act, Form 3 not of Patent Act, Form 3 of the VD Act, and we have to sign ABS agreement with them. So under that agreement, we have to fulfill several commitments, and those commitments we have fulfilled for 3 patents. We have fulfilled for all, but 3 since have been commercialized. Excuse me. So one is a formulation for blood sugar lowering, which is in the market in the name of BGR34. So we have shared license fee, 2% of license fee, and certain mutually agreed percentage of the royalty. And every year we send a draft to National Gene Fund or something, it's the National Biodiversity Fund, by draft to Chennai. Other 2 are, one is a toothpaste based on plant material, and one is the cough syrup. So we have shared whatever mutually agreed percentage for license fee and the royalty which we have received, and we share it every year. Other commitment which include is that you have to disclose, you disclose in Form 3 also, but also there is one annexure in this ABS where you have to give all the details of the biological material, which include common names, scientific names, resources, part of the biological resources, what is the geographical location from which you have taken it. So this is the second commitment which anybody who has signed ABS will have to do. This you do while making the agreement itself. This I have just told. Next, please. That is also one more important thing, is that you have to inform. So say if you have filed your application in 5 or 6 countries or even in India, you have to update Biodiversity Authority about its status every year. Within 60 days or 90 days, you have to also inform if it is granted. So status you have to inform. They have prescribed a pro forma for that, in which it has to be chartered accountant certified. So we, in the first year, we have shared around 72 such stated reports for different patent application originated from us. And I will just show you one sample of it. Next. So this is the pro forma in which we have shared this was, I was referring earlier also. So this detail include the country where it has been filed, your patent application number, its status, that it is granted or under examination or filed. Mode of commercialization, there may be commercialization that applicant himself, like what I read in the beginning, L&T must be doing himself, so if it is L&T is getting a status report, if using bilateral material of force. So there you can do it by yourself, or you can write, can be licensed and rights can be assigned. So these are the modes with which you do, then whatever factory says, if you are doing it or your licensee is telling you, you have to take those details from them. So that you have to fill and all the details of licensing, that amount which you have received, and accordingly you calculate the percentage and tell them every year, and also send the draft to biodiversity authority. So you have to do it every year for each jurisdiction. One patent is filed in 5 countries, you will have to submit, either you submit 5 status report, because you cannot put all, this I acquired from that, you cannot put all 5 names in one. So only thing is that for every form, chartered accountant will charge you some 1,000 rupees for stamping, so it is additional expenditure. Next, please. In case if you missed out in some commitment, as was believed by authority in one case, so they also asked us to make awareness program about biodiversity authority, its conservation, and the act itself. So we organized one program on this, which was joined online. It was COVID time, of course. So it was joined online by ex-Secretary of Kerala Biodiversity Authority, and more than 150 students, including from CSIR-INDIAN and other different colleges and my CSIR sister laboratories here. Next, please. Now, there are certain issues with this particular act, which we deliberate among ourselves, but we have to follow what law says. First is that what is the duration of benefit sharing? So if you go by the life of the patent, it is not like that. You will find that even though you are applying in Form 3 for getting permission, you will have to continue paying them royalty and all whatever amount agreed till you are getting it, even though that patent has expired or its term is over. So that is one issue which is there, and it is still like that. Only if you sign, you will find that till you get the royalty, so you will get it. Second issue, which is a food for thought, you can say, is that even though practically while doing research, we are not accessing biodiversity, we are purchasing it from someone, even then we have to share it with the biodiversity authority, because that is how the act is. So that is what I just wanted to share. So if you have any query. Please.
Regarding filing of patent through an institution, what is the percentage of this benefit sharing in terms of monitoring curve?
Within institution or outside institution?
Within institution.
So within institution is your policy, because within institution, like with CSIR, presently, though it is under revision, we have been inventors and there are different categories, the main inventors, the supporting staff, business development staff, and all the lab. Everyone is given certain percentage of the monetary benefit coming to the institute. And from that certain percentage, different categories have been allotted percentage. So this might be, I'm not aware, but this might be the case in ICAR also. So it is your internal mechanism. It has nothing to do with either Patent Act or BDA. BDA Act is for the benefit sharing with those who have really just like हमारे यहाँ किसान हमारे यहाँ पे बैठे हैं, इन्होंने अगर कोई चीज कंजर्व की हुई है और सदियों से, कोई ट्रेडिशनल नॉलेज इनके पास है और हम वहां जाते हैं या कोई बाहर में जाता है उसके बेसिस पे कुछ कमर्शलाइज करता है, तो ये एक्ट उनको वो बेनिफिट देने के लिए है कि जो सदियों से इन्होंने इनके जनरेशन ने उसको प्रोटेक्ट किया, नर्चर किया, तो दे शुड गेट बेनिफिट ऑफ इट। वो उनके बेनिफिट के लिए बेसिकली है। इंटरनल सिस्टम इज टू ऑर्गेनाइजेशन। थैंक यू।
Thank you very much, sir, for sharing your profound knowledge with us. Now it's time for tea break. I would like to request to all of you move outside. We will be resuming here after 15 minutes. Kindly come inside so that we can restart the session. Welcome back. We are honored to have with us Dr. Sripati Rao Kulkarni, Principal Scientist and Coordinator, IPRs and International Relations, Central Drug Research Institute, Lucknow. Now I would like to request Sir to kindly deliver his talk. Please welcome to the Sir with a big round of applause.
Sure. Uh, Thanks to Dr. Mishra and Dr. Srivastava for setting the tone right for understanding of intellectual property rights. जैसे उन्होंने पहले ही बताया था कि ये टॉपिक एक ही है, स्पीकर्स अनेक हैं, तो ये रिडंडेंसी और रिपीटिशन तो रहता ही है, but I try to take up some other issues which have not been discussed and we try to engage in mostly interactive session रखते हैं इसको. जिस तरह से क्वेश्चंस आ रहे थे तो मुझे लगा कि आई शुड बी डीलिंग मोर ऑन द बॉडी ऑफ द पेटेंट एंड कैसा पेटेंट क्या होता है और कैसा दिखता है और क्या 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 उसमें होने चाहिए क्या क्या नहीं होने चाहिए एंड he will also cover the fundamentals and contemporary issues a little later. So I come from Central Drug Research Institute. जैसे ये भी CSIR का ही एक लैब है जो CSIR का हेडक्वार्टर्स रहता है दिल्ली में, बट उसके 37 डिफरेंट लैबोरेटरीज अक्रॉस इंडिया है और लखनऊ में तो 4 लैब्स है हमारे, एक CDRI है और MBRI, CMAP और IITR. Each lab का mandate अलग होता है. So what we do is different from what Vivek's Institute does. Likewise. So today's topic, I thought, though it is entitled as this protection and management of infections, but we'll try to understand what exactly are these failures. Okay. So, yeah. So जैसे assets अगर हम समझते हैं कॉमर्स में पढ़ाया जाता है कि tangible assets और intangible assets. जैसे हमारा कार होता है या बिल्डिंग होता है या कोई मशीनरी होता है या कोई भी व्हीकल हो या ऑफिस फर्नीचर हो, all these are physical assets या tangible assets जो हम fixed assets होते हैं जो हम टच कर सकते हैं. This is a tangible asset. लेकिन उसी तरह से कुछ इंटेंजिबल एसेट्स भी होते हैं जिनका भी वैल्यूएशन बहुत ज्यादा होता है, लाइक पेटेंट्स, कॉपीराइट्स, ट्रेडमार्क्स, जिनको हम टच नहीं कर सकते हैं, बट स्टिल दे आर ऑफ ह्यूज इमेंस वैल्यू टू द सोसाइटी. ओके, पेटेंट्स, ट्रेडमार्क्स है, गुडविल है, मैन्युफैक्चरिंग प्रोसीजर्स, एसओपीज. तो डेफिनेशन तो आप समझ ही गए होंगे अभी तक IPRs क्या होते हैं. Those are the legal rights actually given by the government to a person or group of persons for the creations of mind. यहाँ पर novelty की बात रहती है, creations of mind and intellect which have some commercial value. So we'll deal with this little later. Or different mechanisms of IP protection. These have been enlisted a couple of times here already. So अगर हम एक example लेते हैं मोबाइल फोन का, this जैसे IPRs are bundle of rights. अगर एक प्रोडक्ट है तो बहुत सारे ऐसे राइट्स होते हैं उनके पीछे कि हम उसको प्रोटेक्ट करके उससे मोनेटाइज करके और कमर्शलाइज कर सकते हैं. जैसे एक मोबाइल फोन का अगर हम एग्जांपल लेते हैं तो उसका shape and look, this will go for the protection of by way of industrial designs. chips and other motherboards हैं, उसके internal components हैं, वो integrated circuit topographies में जाता है, motherboards especially and chips. Then the technology used in the antenna, microphone, speakers, internal chips, ये सब patents के जरिए protect किया जा सकता है. Then the trademark itself, like iPhone है, Apple का या Samsung का है, so that itself goes as a brand name, brand image. तो trademark के जरिए होता है. The literature associated with it goes by way of protection of the copyright. So these are the different bundles. आप एक product को के बारे में सोचेंगे तो उसके पीछे बहुत सारे bundle of rights associated होते हैं जिससे आपको monetization में आपको मदद मिलती है. So that is one thing. एक example मैं छोटा सा देना चाहता हूँ कि दो to understand the concept of IP and the importance of patents. इसके वजह से ये example बता रहा हूँ. So both Mr. X और Y रहते हैं, both work hard, both document their observations that are coming out of the experiments conducted in their laboratories. फिर वो अच्छे से इंटरप्रेट करते हैं रिजल्ट्स को, देन एक अच्छा पब्लिकेशन हाई इम्पैक्ट फैक्टर जर्नल में पब्लिश करते हैं और उसके जरिए लोगों को पता चलता है कि उन्होंने क्या काम किया है. So Mr. Y, being a little bit smart researcher, what he does is he incorporates one more step before publication to a journal. और जो कम्युनिकेशन टू a journal जो होता है, अपना काम किसी जर्नल में पब्लिश करने से पहले वो क्या करते हैं कि उसका इम्पोर्टेंस समझते हुए उसको प्रायोरिटी सिक्योर करते हैं. प्रायोरिटी का मतलब होता है एक पेटेंट एप्लीकेशन फाइल की, देन वो पब्लिश किया. So इसके वजह से क्या हो गया है कि he gets rewarded, monetary हो या दूसरे तरीके से भी. And what kind of rewards we are talking? जैसे एक एग्जांपल है, मोटोरोला मोबिलिटी एक कंपनी था जो अपने पेटेंट्स पोर्टफोलियो को जब उन्होंने बेचा है, बेचने के लिए रखा है नेगोशिएशंस में. So all that portfolio of 24,500 patents have been sold for $12.5 billion. So you can imagine the importance of intellectual property and intangible assets behind that. वो कितने लाखों के हेक्टर्स हो सकते हैं जो आपको $12.5 billion दे सकता है. So that is the importance of intellectual property. जो माइंड का जो एक्सपेंस का यूज यूटिलाइजेशन है, that gives you a lot of things. जैसे छोटी सी कंपनी थी नोवेल जो 882 पेटेंट पोर्टफोलियो को $450 million में बेचा. There are several examples कि लाखों करोड़ों में बिकते हैं एक पेटेंट, लाइसेंसिंग हो या सेल हो जो भी. So that is the importance of intellectual property. And recently there was a takeover by Microsoft of the Nokia patent portfolio. So if we see the entire company had been taken over by Microsoft, whose total deal का value था $7.2 billion. And उसमें से $2.17 billion was only for intellectual property. So that is the patents and other IP mechanisms. So that is the importance of IP. I want the attention of this group towards the importance of these patents and the bundle of rights that are associated. Okay. So coming to the patents, सुबह से हम लोग बात कर रहे हैं कि patents है और IPRs है. What is this patent all about? It is, as I was telling you, it is equivalent to your any of your tangible asset. जैसे आपका एक बिल्डिंग है, आपके नाम पे है, तो आप उसमें रह सकते हैं या किसी को रेंट पे दे सकते हैं या अबैंडन भी रख सकते हैं या ऐसे ही छोड़ सकते हैं. Whatever you want, you can do with it because it is your property and that is your physical property. Similarly, these IPRs can be treated. जैसे आपका एक पेटेंट है तो आप इसको यूज कर सकते हैं या लाइसेंस कर सकते हैं या ऑफर फॉर सेल भी कर सकते हैं. एंड दीज आर योर प्रॉपर्टी. जैसे आपका कंपनी बैंकरप्ट हो गया तो मॉर्टगेज भी कर सकते हैं, उसको बैंक में रख के उसके नेक्स्ट उसका वैल्यूएशन भी होता है और उतना प्राइस आपको लोन भी मिल सकता है. सो लाइकवाइज एंड द टर्म ऑफ पेटेंट जैसे ये बता रहे थे कि 20 years from the date of filing होता है. एंड इंडिया के जो भी पेटेंट्स ग्रांटिंग एजेंसी होती है वो कंट्रोल जनरल ऑफ पेटेंट्स है, इंडियन पेटेंट ऑफिस. They have 4 branches: Delhi, Mumbai, Kolkata, and Chennai. So moving ahead, पेटेंट्स किस तरह के पेटेंट्स होते हैं? कोई प्रोडक्ट भी पेटेंट कर सकते हो आप, कुछ नया कंपाउंड के बारे में सोचा या कोई नया फॉर्मुलेशन के बारे में सोचा. Those could be patented, and the processes by which you will define that particular product will be used by synthesis of this synthesis by the way of this process वो भी पेटेंट कर सकते हैं. उसका यूटिलिटी भी होता है, यूटिलिटी पेटेंट होता है, डिजाइन पेटेंट होता है, एंड प्लांट वैरायटीज आर लिटिल डिफरेंट. वो सुई जेनेरिक्स नहीं चलता. कभी कभी आप अगर चाहते हो अपने ही कंट्री में फाइल कर सकते हैं, उसको नेशनल पेटेंट कहा जाता है. और अगर आपको अच्छा लगता है, जैसे हमने किसी द्वारा ये एक अच्छा सा एंटी कैंसर मॉलिक्यूल आइडेंटिफाई किया, और कैंसर इज प्रेवलेंट एवरीवेयर इन सेवरल नेशंस, सो वी वुड लाइक टू प्रोटेक्ट इट इन अदर कंट्रीज आल्सो. तो ये इंटरनेशनल पेटेंट्स थ्रू ईसीटी रूट या इंडिविजुअल कंट्रीज में जाके हम कर सकते हैं. सो दैट इज द मोड ऑफ पेटेंट. अगर आपके पास एक पेटेंट है तो आपको किस तरीके से इसको इस्तेमाल कर सकते हैं, और कौन कौन से एजेंसीज या एंटिटीज रहते हैं जिसको आप आंसरेबल होंगे या अपने इन्वेंशन को प्रोटेक्ट करना है. सो दिस वुड बी द एग्जामिनर्स. जैसे ये पिक्चर है तो एक समुदाय वॉरियर है, and all these intellectual properties entity mechanisms are his weapons. एक आप अगर मार्केट में उतर रहे हो आपके कंपाउंड वेस्ट, मनी एंड माइंड पार्ट तो हमारे पास है ही, जो हमारा नॉवेल्टी नॉन ऑब्वियसनेस और यूटिलिटी पार्ट को ऑब्वियस करता है. But money, that is more important when it comes to commercialization of these technologies that we are thinking of to develop. Okay. Next slide. Yeah, next. Yeah. जो भी पेटेंट करने जाता है उसके मन में 2-3 क्वेश्चंस आते हैं. क्या फाइल करना है पेटेंट के तौर पे, और कहाँ फाइल करना है, कैसे फाइल करना है, ये सब बातें. Then what to file is, if we see, then it could be a compound patent, it could be a process patent, or it could be a formulation patent or a composition patent. Then next, when to file. This is more important. अगर आपके पास एक इन्वेंशन है और आपको अगर लगता है कि ये बहुत इम्पोर्टेंट इन्वेंशन है और इसके दिस इज मोर has more potential and इसका competition ज्यादा है, but आपके initial results ही potential लग रहे हैं, लेकिन you need to do lot of work behind that. Then आपको एक provision दिया गया है इंडियन पेटेंट ऑफिस के थ्रू कि आप एक प्रोविजनल एप्लीकेशन डाल दें और नेक्स्ट 12 मंथ्स में आप उसको कंप्लीट फाइल कर सकते हैं विद अ प्रॉपर सेट ऑफ क्लेम्स. अगर आपने बहुत ही जल्दी पेटेंट फाइल कर लिया, and there is always a possibility that you will use time in completing that experiments and in जैसे compounds की बात करता हूँ, drugs की बात करता हूँ, तो अगर हम in vitro studies से ही हम पेटेंट फाइल करते हैं, but lot of time goes in vivo animal studies and human clinical trials. So इसमें बहुत सारा टाइम यूज करते हैं. जब तक हमको DCGI परमिशन मिलता है मार्केट करने के लिए, तब तक तो 15 साल निकल चुके होते हैं. तो 20 साल में 15 साल अगर निकल गए तो व्हाट वी कैन डू विद द रेस्ट ऑफ 5 years. सो अगर आप बहुत ही लेट कर दिए हैं, जैसे पूरा IND फाइलिंग तक ले गए, सारे इन विट्रो इन वाइवो रिजल्ट्स आने के बाद IND फाइल अगर करने तक हम गए हैं, तो वेट कर रहे हैं, तो देयर वी विल बी लूजिंग द इन्वेंशन. देयर इज ऑलवेज अ पॉसिबिलिटी कि हम हमारे स्टूडेंट्स कहीं पब्लिश कर दिए या कहीं दूसरे कोलैबोरेटर्स ने पब्लिश कर दिया, जॉइंट एप्लीकेंट ने पब्लिश कर दिया, कहीं कोई डिस्क्लोजर हो गया, then we again there is a possibility of losing that invention. So where to file, what to file, when to file, ये important होता है to understand the patent. Next slide. Then where to file. जैसे मैं पहले बताया था कि अगर आप इंडियन बाय डोमिसाइल हैं तो इंडिया में फाइल करना चाहते हैं तो you can do that. But if looking at the protection of that compounds or inventions, you have a possibility of filing in many countries through these PCP. Next. Yeah, let us come to the procedures that are followed at the Union Patent Office. जैसे मैंने बताया कि अगर आपके पास invention ready है, but still if you are looking great and if you are anticipating some more results, then you have a provision to file it as a provisional specification. Then 12 महीने के अंदर उसको complete specification file करना है. Then based on that priority, the age of the term of that patent is decided. And 18 महीने के बाद it will be published by way of a gazette in the website of that Indian Patent Office. That is called the publication stage, which is a little different from the publication of your manuscript in any journal. Publication of a patent is different, which in which they say कि ये title से ये inventor से ये patent से with this abstract and all they are fine. एक छोटा सा nutshell में आपके invention के बारे में बताया जाता है to the public. Then उसके बाद you have to request for the examination. 4 years के अंदर आपको ये by way of filling of a form 18, you have to request the Patent Office to examine your invention. अगर ये नहीं करते हैं तो आपका invention examine नहीं. You have to be very careful that no communications comes from the Indian Patent Office की आपका इस stage पे है. Once it is published, then you have to request for examination. Then the examination happens. वहाँ पर first examination report generation and second examination report generation. Then if they are not satisfied, if the examiner is not satisfied, it goes to hearing. ये भी होता है और वहाँ पर based on your negotiations with the examiners and controllers, it will be granted. एक set recommendation for the grant of the patent जाता है examiner के तरफ से controller and controller grants that. So grant के बाद क्या होगा? That is also a big thing. आपके नाम पे आपके प्रॉपर्टी हो गया ना that patent. तो आप समझेंगे कि अरे मेरा प्रॉपर्टी है मैं कुछ भी कर सकता हूँ उससे जैसे कि मैं बेच भी सकता हूँ लाइसेंस भी कर सकता हूँ या कुछ भी कर सकता हूँ या ऐसे कर सकता हूँ ऐसा नहीं होगा अगर there is always also a provision in patent office कि अगर कोई 3 साल के अंदर उसको कमर्शियलाइज नहीं कर पाया और दूसरा कॉम्पिटिटर के पास सारा इंफ्रास्ट्रक्चर है वो करना चाहता है तो 3 साल तक अगर आप इसको यूटिलाइज नहीं कर रहे कमर्शियलाइज नहीं कर पा रहे तो then you they have a provision to take a compulsory license and take it further ये भी एक provision है ओके एक केस हुआ था ऐसे ही सोराफन का केस जो बायर एक कंपनी शर्मा का BAY you might know that so they came up with an anti cancer company जो इंडिया में 1,20,000 per one month treatment के लिए यूज किया जा सकता है so that is expensive for the middle class Indians over city तो वो लोग काम नहीं कर रहे थे they were request for waiving off या reduction in the price of that sorafenib तो एक नाटको एक कंपनी है हैदराबाद बेस्ड स्मॉल कंपनी they went to the central government and the Indian Patent Office saying that ये unaffordable prices पे ये लोग बेच रहे हैं we have all the infrastructure to do it at a lesser cost so they asked for the compulsory licensing and it went to the courts बहुत सारा arguments और बहुत सारे हुए and finally the government looking at the importance of this they said that they इनको compulsory license दिया है and NACO came out with a same compound same activity same protection for just 8,000 rupees instead of 1,20,000 rupees NACO came up for 8,000 rupees so that is the importance of intellectual property so you can be played around with the rules regulations and laws next slide next so let us try to understand what patent document actually looks like it's a small a bunch of papers जिसमें these are the entities that can be seen in a patent document एक bibliographic information होता है, एक prior art होता है, then description, claims and drawings. Bibliographic information में सारा कुछ first page अगर आप देखते हैं तो ग्रांटेड पेटेंट का तो पूरा इंफॉर्मेशन एक ही जगह वन पेज पे कंसाइज दिया जाता है, जिसमें टाइटल भी देखा जाता है, इन्वेंटर्स कौन है, एग्जामिनर्स कौन है, so that details can be seen. And okay, next one. Yeah, like this. ये सारा कुछ इंफॉर्मेशन बिब्लियोग्राफी का यहाँ मिल जाता है. ओके, देन अगर डिटेल देखा जाता है तो टाइटल शुड बी स्मॉल, वेरी वेरी, जैसे 10-15 वर्ड्स का होना चाहिए, मीनिंगफुल. देन इन्वेंटर्स कौन हो सकता है, दिस इज अ बिग क्वेश्चन. जैसे जो भी इंटेलेक्चुअल इनपुट इसके लिए क्लेम्स के लिए देता है, दोज पर्सन कैन बी एन इन्वेंटर. Likewise, जैसे हमारे लैबोरेटरी में अक्सर एक लैबोरेटरी टेक्निकल स्टाफ होते हैं जिनका काम ही, they are paid for preparing reagents or preparing those equipments for running the laboratory. ऐसे लोगों को जो एक्चुअल इंटेलेक्चुअल इनपुट उसको नहीं देते, those cannot be an inventor. भले ही वो रिश्तेदार हो या फ्रेंड हो या जो भी हो. But only those people who have actually contributed to the claims of the invention. जिनके contribution के बिना आपका invention पूरा नहीं होता है, those could be included as in the list of inventors. और assignee होता है in दूसरा term, जो like in our cases, like we work for CSIR. So CSIR funds our projects, and उनमें उस projects में से inventions निकल आते हैं. Then CSIR will be assigned because they are paying for this entire projects. Okay, and the one who had contributed towards the claims will always be an inventor. These two are different entities. Next, please. Next. Then एक priority date होता है जहाँ पर first date of applying for this patent in that technology. Next, एक publication तो हमने बात की है. Next, this is all about the international classification codes and categorization of technologies. Next, yeah, prior art एक होता है, that is more important. जैसे आप आज के दिन आपका एप्लीकेशन फाइल कर रहे हैं तो जो भी टेक्निकल इंफॉर्मेशन दैट इज अवेलेबल अबाउट योर इन्वेंशन बिफोर द डेट ऑफ फाइलिंग ऑफ योर इन्वेंशन, filing date of your invention, all that is considered as a prior. And उसके जो एग्जामिनर जब आपका इन्वेंशन देखता है तो उससे पहले वाले दिन तक जितना भी इंफॉर्मेशन है वो सारा सर्च करके वो एस्टैब्लिश करता है कि आपका इन्वेंशन डिफरेंट है, then only he will grant that patent. Next. उसके बाद होता है कंप्लीट डिटेल्स ऑफ दैट इन्वेंशन, जो डिटेल डिस्क्रिप्शन ऑफ इन्वेंशन होता है, जहाँ पर छोटी छोटी माइनर चीजें लिखे जाते हैं कि आपने एक्सपेरिमेंट कैसे कंडक्ट किया, आपके रिजल्ट्स कैसे आए, ऑल दोस थिंग्स. देन नेक्स्ट प्लीज. देन क्लेम्स का इंफॉर्मेशन बहुत ही इंपॉर्टेंट होता है. जैसे क्लेम्स, जैसे आप एक कॉलोनी में रहते हैं और आपका घर है, घर को आपका कॉलोनी से डिफरेंशिएट करता है आपके घर का कॉम्पाउंड वॉल, राइट? योर दैट इज द बाउंड्री वॉल ऑफ योर प्रॉपर्टी. सिमिलरली द क्लेम्स डिफाइन द स्कोप ऑफ द इन्वेंशन, और आप क्या क्लेम किए हैं और क्या नहीं किए हैं, लीविंग द स्कोप फॉर अदर्स टू एंटर इनटू दिस. और किस हद तक आपका क्लेम का स्कोप बना है जो दे कैन नॉट एंटर इनटू योर. So this is very technical matter, but still claims are the important part of that patent, where they are evaluated and examined in view of the prior art. Okay, next. This one example. Next, yeah. Inventorship के बारे में मैं बता रहा था कि not any Tom, Dick and Harry could be an inventor. There are very clear and guidelines and understandings of who can be an inventor, right? इस example में अगर देखते हैं तो एक we have to file a patent application with a claim लाइक एक एडिसिव कॉम्पोजिशन है comprising A, B, C and D parts. अगर आप इन्वेंटर 2 का पार्ट देखते हैं तो इन्वेंटर 2 had contributed for part D only. अगर ड्यूरिंग द प्रोसिक्यूशन अगर एग्जामिनर को लगता है कि ये पार्ट डी जो है दिस इज रिडंडेंट एंड इट इज ऑलरेडी अवेलेबल इन द प्रायर आर्ट, इट कैन नॉट फॉर्म द पार्ट ऑफ एन इन्वेंशन, तो उसको निकाला जा सकता है। व्हेन दैट पार्ट डी इज रिमूव्ड ऑब्वियसली द कंट्रीब्यूशन ऑफ इन्वेंटर 2 हैज गॉन, सो ही कैन नॉट बी एन इन्वेंटर। Likewise, very clear understanding about that one needs to have while defining the inventorship. Next, please. ओके, जब आपका एप्लीकेशन भेजा जाता है तो देयर आर सर्टेन क्राइटेरिया फॉर द एग्जामिनर टू लुक एट। पहले वो नॉवेल्टी के लिए देखते हैं, जितने भी आपका प्रायर आर्ट इंफॉर्मेशन है और अगेंस्ट योर एप्लीकेशन अगर ये किसी अदर डॉक्यूमेंट में एज सच अवेलेबल है तो देन ही विल नॉट रिकमेंड फॉर द ग्रांट, दैट शुड बी डिफरेंट फ्रॉम अदर्स, देन दैट इज कॉल्ड द नॉवेल्टी एस्पेक्ट ऑफ इट। नेक्स्ट, and the most important thing is non-obviousness while examination of patent goes. This is very crucial and depends on the examiner's awareness about that or expertise in that technical domain. कभी कभी वो ऐसे क्वेश्चंस पूछते हैं कि आप आंसर नहीं दे पाते because of your understanding. You are viewing your application or the set of claims in a different way than the examiner looks at. So we have to be very careful in defining the set of claims and the scope of claims. Okay. Next, उनको एग्जामिनर को ये नहीं लगना चाहिए कि ये 4 डिफरेंट रिसोर्सेज से एक पार्ट निकाल के एक इन्वेंशन बना के भेजे। There he should always we should always leave a scope that हमने कुछ intellectual input दिया है, then only he will be able to understand what is that intellectual input which is different from the prior art, which he can recommend for the grant of तभी ये। Then the utility part, benefit of the society is the crux of the issue. हर पेटेंट एप्लीकेशन में आप एक यूटिलिटी पार्ट दिखाना चाहिए, that is one. Okay, next, ये 2-3 slides निकाल दीजिए। Next, yeah, please I leave for the next presentation, please. Yeah, then the searching of patents literature is very important. अगर आप मतलब if you are not satisfied that you have searched enough in all the domains that are available in black and white, चाहे वो लाइब्रेरी में से बुक हो, प्रिंटेड मटेरियल हो या न्यूज़पेपर क्लिपिंग हो या कोई प्रोसीडिंग्स हो किसी कॉन्फ्रेंस का, कहीं भी अगर इंफॉर्मेशन अवेलेबल है ब्लैक एंड व्हाइट, देन दैट इज कंसिडर्ड एज अ प्रायर आर्ट. So you should be very careful in establishing your patentable subject. Okay. कुछ इसके लिए आपको इंटरनेट बहुत यूजफुल रहता है, जैसे गूगल पेटेंट्स है या यूएसपीटीओ का वेबसाइट है, वाइपो का वेबसाइट है या इंडियन पेटेंट ऑफिस का वेबसाइट है, या each and every patent office has their website with searching mode, and जो भी उनके पेटेंट्स अवेलेबल है वो सब उसमें डेटाबेसेस के रूप में दिया जाता है. Okay, next. So next we'll go ahead for some more slides. Yeah, next. These are examples how to conduct the research and or search and all. Yeah, next. Yeah, ये तो एग्जाम्पल उन्होंने बताया है, मिश्राजी डायमंड वर्सेस चक्रवर्ती वाला केस जहाँ पर सुडोमोनास ब्यूटिडा वाला था. वहीं से बायोटेक्नोलॉजी रिलेटेड पेटेंट्स का एडवेंट एक ईरा स्टार्ट हुआ है, because microorganisms were not allowed to be patented earlier, but this particular case, Anand Chakraborty, because he could convince the Indian USPTO that he had actually changed the genetic material by way of recombinant DNA technology. Then only they have granted this. उसके बाद कॉम्पोमाउंस वगैरह बहुत सारे ऐसे बायोटेक पेटेंट्स आए हैं. नेक्स्ट ये बासमती टर्मरिक वाला केसेस तो आपको पता ही है. नेक्स्ट Yeah, this is all about that. This was a particular reference with which we in India could gain its edge above other countries for protecting our traditional knowledge. यहाँ पर जो टर्मरिक ब्रेकिंग था वो वुंड हीलिंग के लिए लिया गया जा रहा था तो दिस पर्टिकुलर रेफरेंस फ्रॉम जामिया हमदर्द लाइब्रेरी आई थिंक इट वाज पुल्ड आउट एंड वहां पर क्लियरली लिखा गया था कि ये जब umbilical cord कट किया जाता है ड्यूरिंग द बर्थ देन द हल्दी इज अप्लाइड ये तो सदियों पुराना टेक्निक है so there through which we could protect our traditional knowledge turmeric paint. Next, please. Next. Yeah. Coming to our little bit of information about our activities. जैसे ये तो IISR है जहाँ पर शुगर केन रिसर्च वगैरह होता है ICAR का मैंडेट है but our mandate is to bring drugs into the market. तो this drug discovery and development cycle इतना बहुत बड़ा होता है like लंबा होता है 8 से 14 साल तक का विंडो रहता है to synthesize a molecule and conduct all the experiments and finally come to a stage where we are given market authorization. And this way, what you put before the negotiations before the commercial partner for negotiations is the patent and know-how, which will be incorporated in that. So patents form an important instrument to negotiate with the commercial partner. Okay. So next, please. So I have one example and thoda sa hatke hai yahan se, which is an important compound that had come from our institute. जैसे बहुत during this is all about that non-steroidal contraceptive pill called Saheli, which CBRI had given to this nation. At the time of independence, India का population इतना ज़्यादा लग रहा था कि family planning, population control should be the mandate of the institute. So WHO के through Indian government ने CBRI को एक mandate दिया था कि they should come out with some contraceptive pill and condition ये था कि ये non steroidal होना चाहिए because उस समय steroidal nature के बहुत सारे मिलते थे which had some side effects. So CBRI was given this mandate and we worked on several molecules. पहले furans पे किया, फिर coumarins पे किया, फिर chromines पे किया, and finally after 8 or 9 years of research, एक chromine molecule, chromans were identified. These are the chemical compounds. एंड उसको इन विट्रो और इन वाइवो बहुत सारे एनिमल्स में टेस्ट किया फिर बाद में सक्सेस हुए देन पेटेंट्स भी हुए एंड देन उसके बाद उसको क्लिनिकल ट्रायल्स में भी किया बहुत सारे वुमेन पे 26,000 साइकिल्स पे टेस्ट किया फाइनली वी केम आउट विद अ टेक्नोलॉजी ट्रांसफर टू हिंदुस्तान लेटेक्स लिमिटेड 1960s में जब स्टार्ट हुआ था 91 में हम लोग उसको कमर्शियलाइज कर पाए. So that was the window we had, the long window to bring out this. And for the last 1990 से अब तक बहुत सारे evaluations भी हुए हैं and no side effects, absolutely safe. That is why it has been included in the National Family Planning Program of India, where ASHA and ANM workers के through they freely दिया जाता है. So I think I thought I would share this particular case with you, the importance of with CSIR laboratories courses. Next, please. Next, one more, please. Yeah. Next. Yeah. Next. Another. Yeah. This particular reunion is coming from plant materials. We have extracted that and standardized that and particular CAFGA component था उसको identify करके then rapid fracture healing के जैसा इसको use किया जा रहा है. This is also coming from CBRI and it is licensed to a company and marketing में available भी है. So जैसे 3 weeks में इसका healing effect दिखता है. That is one breakthrough invention coming from our laboratory. Next, please. So I will leave with a thought. Next, yeah, this thought. किसी कॉन्वोकेशन में नारायण मूर्ति कह रहे थे कि पिछले 60 साल में अगर इंडिया से कोई ऐसा इन्वेंशन नहीं आया जो डोमेस्टिक यूज हो. So let us strive for bringing that. Okay. Thank you.
Thank you very much, sir, for sharing reflective knowledge with us. It will be my honor to invite Dr. Vikas Bhati, Assistant Professor Dr. Ram Manohar Lohiya, National Law University, Lucknow. His particular area of interest includes intellectual property law, cyber law, law science and technology, biotechnology, law, nuclear law, and international space law. I would like to invite Dr. Vikas Bhati to kindly share his experience on the topic intellectual property rights, fundamentals, and contemporary issues of and challenges. Please welcome to the sir with a big round of applause.
Good afternoon. Rahul Vishwanathan, Dr. J.P. Mishra, Dr. Vivek Srivastava, Dr. Shripati Rao, Dr. L.S. Gangwar, Dr. A.K. Sharma, Dr. Kamini Singh. I'm delighted to be offered an opportunity to interact with the scientists. We too often talk with the people having background in the law. But these sort of opportunities seldom comes to us. Though as far as Sugarcane Institute is concerned, I am back to it after almost a decade now. So anyways, my topic for today is intellectual property rights, the fundamentals and contemporary issues and challenges. At the outset, the many things have been discussed, but there are certain points I would like to add to what has already been told to you. Moving on to the first slide. When we talk about intellectual property, as Dr. Shripati was saying that with respect to the intangibles, which in common sense means things which can't be perceived by our senses as tangibles can be. But there are two important characteristics which differentiate a tangible from an intangible. This is important to know because we know that the subject matter of intellectual property rights are intangibles. Intangibles, unlike tangibles, are non-exclusive. That is to say, that take an example. If I had an apple, I'm the owner of that apple. That apple is a tangible asset which belongs to me. Now, my legal right would be that fruit cannot be taken away from me. And if taken away from me, I have every right to receive it back. As it is. I can even put it under lock and key. That means that I can perfectly exclude others from having the possession of it. And if they do have without my permission, I can recover it back from them. That doesn't go with intangibles. For a story, so I can lock the cable. I'm not locking the story. And if I tell you the story, there's no way I can take it back from you. It remains. I cannot further exclude you from having the possession. And story is not an apple. Subject matter of intellectual properties are not excludable as tangibles are. Secondly, their consumption is rivalrous, tangibles. And that's not the case with intangible property. Take an apple again. If I choose to distribute an apple amongst 4 people, the amount all of them would be getting is a quarter of piece of that apple, not the entirety of it. But if I tell you a story, with those 4 people, they would be getting the entirety of the story, each of them, not a part of the story. And if they share it with 1,000 more people, And those thousands went on to share it with lakhs of the people. Those thousands, those lakhs, those millions would be getting the entirety of the story, not a portion of the story. So it can be consumed unlimitedly with unlimited number of people. The value of that property would remain to be the same for everyone. And that's not the case with an apple. Its consumption would be rigorous. So these two characteristics, therefore, differentiate subject matter of intellectual property from the traditional property as we know. This difference is one of the reasons that the traditional property laws, the land law, the sales of goods, they're not apt for dealing with intellectual property issues. So we need a separate. This also poses us with a question that why to play? Several reasons have been given, several policy reasons have been cited. But the core reason is that intellectual property rights serves as a guarantee that once you had obtained, once you had created, once you had invented an eligible subject matter, then the law guarantees that it should be protected against unauthorized use by another person. This acts as an incentive for a person to invent, to express, to create at the first place, to invest in building reputation and goodwill. Now imagine a society, imagine a legal system where there is no law to protect this. What would happen? Now, Dr. Shripati would agree that manufacturing or inventing a drug is a costly process. Being aware of that, being knowing that inventor knows that a sunk cost would be going into making a drug. A sunk cost is that cost which is already gone. And the only way to recover that cost is from the market by way of commercialization of that end product. Now, if there is no patent system, what would happen is that other persons would be free to copy it without any restriction. Now, those other person who has copied it has not incurred any sunk cost. There was no research and development cost. So he has no burden. He need not recover it from the market. The only cost would be the production cost. So he would be able to sell the same product at a lower price as compared to the true inventor. So the common sense would tell the inventor, because an inventor would also be a man of common sense. That is not to invent, because he would not be able to recover the sunk cost. Well, that means in the longer run, though some may argue that this would lead to a result that the same drug is available to us at a lower price. This proposition seems to be attractive from a face value, but that's not true. Because in the longer run, what would happen is that none of the people who can innovate, who can come up with useful products or processes would eventually do so. They would not. Right? So what the society would suffer from is an underproduction of useful things, intellectual products. This is tragedy of commons. Dr. Mishra would agree with me, being from the economics background. Tragedy of commons is when you declare something to be a public good. In case of tangibles, the problem that would arise as a consequence is a problem of overconsumption. To declare a land to be a public good, that the people would be willing to consume the resources of that land prior to relying on their own resources. So there would be overcome. People would be using it first before using their own resources. In case of intellectual creations, this problem manifests itself in a different manner. There won't be a problem of overconsumption if you declare knowledge to be a public good. The primary reason for that is that the consumption of intangibles is non-righteous. So it can be consumed endlessly. So if it can be consumed endlessly, there can't be an overconsumption of that. So rather, another problem of the race, that is, it would not be created at that. That is, the amount of creations that would come out would be at its lowest. I'm not saying it would be zero. I'm saying it would be at its minimum. Right? So to avoid this problem of underproduction, we have a mechanism of intellectual property rights system, the laws, which guarantee the protection to the intellectual. But this is demonstrated by the graph. X is the amount of IP creation and Y axis is the amount of IP protection. The amount of IP protection is zero. The amount of IP creation is not zero, but at its minimum level. It's not meeting at zero. That line is not meeting at zero. And as you increase on X, you also increase on Y. Increase the level of IP creation protection, the amount of IP creation also increases. Types had already been discussed. Now, this just one additional thing to say here. This is not an exhaustive list, and this may depend upon jurisdiction to jurisdictions. Some jurisdictions allows design patents too. Some jurisdictions allows utility patents. Right. So it may vary depending upon which jurisdiction you are speaking about. As Mishra sir and Srivastava sir has also pointed out that these rights are territorial rights. So depending upon which territory you are in, you speak about the particular intellectual property rights which could be allowed within that jurisdiction. Secondly, it's an ever expanding category. So there is a talk of new form of intellectual property rights not to be agreed, at least theoretically, to be incorporated within this, under this umbrella of religion. Say, for example, traditional cultural expressions. So it can be mass, it can be folk songs, etc., etc. Can come under its ambit. Next, please. Patents Act. Most of the things have been discussed. There are certain provisions which are directly relevant for biotechnology. I will discuss those along with the depository requirement, which had been discussed in part 2. Substantive requirements are 4 in under the patent. First is it must be a product of process. When we say product of process, we are not talking about two things. It may seem to us that either it has to be a product or either it has to be a process. But that's not the case here. It's actually 3 things. Because in law, interpretation of law, the principle is if the word "and" or the word "or" appears somewhere in the legislation, it can be interpreted in either way. So "and" can mean "and" as well as "or." Likewise, "or" can mean "or" as well as "and." It depends upon the context. So here the "or" would mean "or," therefore 2 things, product or process. But in this context, "or" would also mean "and." So there is one more category of subject matter which is product by process. So there are 3 possible subject matters: products or processes or product by process. This is subject matter of patents. Now, as far as these products or processes which are patentable is concerned, there is no positive list in that. That this are patentable. No. Instead, what the law does is it gives us a negative list. That these are not patentable inventions. Under section 3 and 4. So the law, the principle therefore is that only inventions are patentable, but all inventions are not. these clauses which I mentioned, the first clause is clause 3J of section 3. It talks directly about the life forms. It says plants and animals in whole or part thereof are not patentable other than microorganisms. So effectively what it is doing is that it has excluded higher life forms. It's not talking about humans. Humans in section 3 had been mentioned separately. So one good question is, does it mean that human parts are patentable? Because plants and animals have been specifically talked. Or is there any another clause in section 3 which prohibits it? Because J is not prohibiting. J is speaking about plants and animals. Humans alag se mentioned हैं. So plants, animals in part or whole thereof are not patentable other than matter. So as far as the product part is concerned, with regard to life, higher life forms are not patentable, but microorganisms are. Then, as the question of humans, humans would not be patentable because an invention which is contrary to morality. Similarly, gene patents, an invention which is contrary to morality. Human being allowed to play God is considered to be contrary to morality. Does not matter. So humans are excluded not by virtue of J, but by virtue of the morality clause. Okay? Microorganisms which are created by man are patentable. The example sir given was diamond versus Chakravarti. But to just give you one more case, which was prior to diamond. In US in 1977, Federal Circuit Court in the matter of Malcolm Burgee, John H. Holtz, and Vedpal S. Malik. So another Indian. They had claimed an invention which involved microorganisms. Now the Federal Circuit Court had not given a direct reasoning and allowed the patentability of microorganisms. But drastically what they did was they equated a microorganism with a chemical. The court is saying that microorganism in some senses behaves like a chemical. And if there is no bar of patentability of chemical compounds, there shall not be a bar of patentability of living microorganisms. This was 1977. This is not as celebrated as Diamond versus Chakravarti. First, it was not Supreme Court. It was Supreme Court. Secondly, it was an indirect court. कहने का मतलब उन्होंने कान को घुमाकर पकड़ा. Diamond versus Chakravarti, they stated directly that microorganisms are patentable. This ruling of the US Supreme Court informed the TRIPS. TRIPS, on the other hand, informed the Indian Patent Act. So J was introduced in its current form with the 2002 amendment. Now, this was with regard to the process of products. With regard to process, essential biological processes for production and propagation of plants, animals, including seeds, varieties, and species, are not patented. So, by way of implication, what we can say is that non-essential biological processes are patentable. What has been excluded are essential biological processes. What has been included are non-essential biological processes. The difference between these two would be the nature of intervention which had gone into creating the claimed subject matter. If the intervention was technical, right, then that would amount to a non-essential biological process as compared to a pure biological process. The method of pruning of trees with the growth of the plant is biological, but the method you are employing, the intervention which is happening in the process of propagation of plant is not technical. Oh, sorry, it's technical. And therefore a non-essential biological process. I compare it with an example of that you are trying to develop a new breed of horse wherein you have chosen the two partners having desired traits in order to have an offspring of having desired traits. Now here, the human application was not a technical intervention. Here it was merely selection of horses with desired traits. The process remains essentially to be biological. So this process is not patented. So biotechnological inventions, considering the question of life forms, only microorganisms are patentable. Higher life forms are not in India. With regard to plants and animals, humans in any form are not patentable. Right? With regard to the processes, non-essential biological processes are patented. Other inventions, other clauses which would be relevant would be clause C. C is discovery of a living substance. It is not patented. Mere discoveries are not patented. As a matter of principle. Discovery is not patentable because we reward something which is new. Discoveries are found. Discoveries are not invented. Invention involves an act of making. Making what? Making something which is new. Discovery is founding something which was already in existence. The discovery of living is not patented. Inventions contrary to morality I had spoken of, inventions contrary to public order, or which can cause detriment to human, plant, animal life, or the environment are also not patented. Chakrabarti is an example where the microorganism was actually useful for the environment. It can be used in a situation of an oil spill. An environmental tragedy can be avoided by using that microorganism. So it has a positive utility. Third requirement of patentability, as we said, 3 things that must be there in a product process. The third was utility. Utility must not be a negative utility. Utility must be a positive utility. If the utility is to cause harm or to disturb peace in the society, that will not be a patentable. Just a microorganism which has a capacity to infect people with diseases. So it's a microorganism. A man-made microorganism, new, non-obvious, but its utility is to cause harm. It's not patentable because of the clause. See. Then we have method of agriculture and horticulture. They are not patentable subject matters. Here, exclusion is with regard to the process and not to the product. I can imagine that this institute doesn't deal solely with the plants as such. There must also be interventions which are relating to agriculture, which might relate to the product can be used in agriculture. So what has been excluded is the method of agriculture or a process pattern. What has not been excluded is the products that have to be used. Another important is the method of treatment. So process of treatment of humans, of animals had been excluded from patentability. Plants was earlier there, but it has been removed by the 2002 Amendment Act. So process for treatment of plants is patentable, but a process for treatment of humans and animals is. Lastly, clause P, which talks about traditional knowledge. So, many cases have been discussed, many examples have been discussed. See, the bar there is that if the claimed invention is in effect a traditional fact, that is nothing beyond, nothing more than that. which amounts to traditional knowledge in effect. That is not patented. Right? But that does not mean that traditional knowledge cannot be relied upon in order to create a patent. What would be denying patentability is which doesn't go beyond the scope of the traditional knowledge, which remains to be within the boundary of the tradition. Patent, developing patents, those all couldn't happen because of the reason that they were ineffective. Alright. Another important requirement is the depository requirement. I'll just move a bit faster. Depository is, apart from other reasons that had been spoken of, because ABS will be shared by Dr. Gam, will be discussed very detailed by Dr. Gam. Depository has been explained by the previous speakers. The importance of this is crucial. One, your patent application must be an enabling one. Enabling in the sense that what you have disclosed must enable the person having ordinary skill in the art. That is, those people. Like for example, an invention relating to agriculture sciences. Then Posita would be an agricultural scientist. He would be able to practice the invention without undue experimentation. Practice here means it's not practice makes perfect. Practice here means being able to make it and put it to use. Right? Now, depository requirement ensures to check by the Posita that whether what disclosure has been made was actually enabling or not. Because enablement cannot be checked without experimenting. Second importance of depository requirement in relation to ABS is that you have to disclose the source of your patent. Once you disclose this, that basically serves as a tool for identifying those people from whom the biological resource has been obtained from, and therefore eventually sharing the benefits with them. The next act is PPVFRA, Protection of Plant Varieties and Farmers' Rights Act, which we have seen in 3J, plants being excluded from patentability. So separate law, which was the mandate of PRIPS, under 27 paragraph 3, which gave member states basically three options: either grant a patent, or either have an effective sui generis system, or either have a combination of both. In India, we had gone for an effective sui generis system. Now go back. One, sui generis का मतलब a system which is tailor-made for our requirements. That is what suits us. An effective system would be, because the word effective has not been defined. So another principle, because many of you are from scientific background, and you would have a method for determining what's the meaning of this. Effective has not been defined in the dictionary. So we do not know what effective means. This is the principle of law. If a word has not been defined, then the definition of that has to be derived from the objectives and purposes of that legislation. So effective word, its meaning has to be deciphered from Article 7 and 8 of the text, which is about sharing of the benefit, transfer of the technology for the betterment of the consumers of the intellectual property. In India, because you are in agricultural sciences, farmers sharing of benefit with them shall be done in order to ensure that it remains to be an effective species. So that's why we had a separate model from Europe. For America, we have a plant patent system. Europe, we have a UPO model. India, we have a separate model. UPO model or the American model is biased towards the breeders. Right? Land variety breeders. While the Indian model is designed to serve the interests of the farmers by many, many means. The requirements are NDUS. I will just mention the requirement of novelty to give you a glimpse into this. Novelty requirement is that and variety is not new if it has been sold or otherwise disposed of. कहने का मतलब
In 1 year.
right, try to the details. कहने का मतलब ये है कि if it is such a case, right? If it has been not been sold or otherwise disposed of, it would be considered to be new. That means that those varieties which are not traditionally sold, but they are known to the public, would still be considered to be new. There are varieties which are exchanged between farmers, not by way of sale. Tulsi plant, traditionally not a subject matter of sale in India. That would mean that being known, but still new. For the fact that it was not being sold or disposed of in that. So novelty, as this definition exists, would mean that things in public domain can be subject matter of breeders' rights. This was a problem in UPO model. I'm just giving you an example to positive. In India, we had adapted the same version of novelty. So what's novel in the Indian law? Indian law बात क्या करता है? It is talking about three kind of varieties. New variety, extant variety, and farmer's variety. Extant variety also include a farmer's variety. But extant variety, I'm not going into the definition at this point. Extant variety is a compilation of those varieties which exist in public domain.
Notified.
And the notified as per the definition. Right? Now, what is there in public domain would come under would came to be known as an extant variety. Now, extant variety registration can be done by a breeder too, apart from institutions or apart from farmers. It can be done by a breeder too, but breeder can't negotiate its commercial expectation. That has to be negotiated by the government. So even though novelty requirement is suggesting to us that what is a matter of public domain can still remain to be new. The provision of extant variety, farmer's variety, ensures that what is there in the public domain is protected as extant variety. And the negotiation, the commercialization of the same cannot be done exclusively by breeder as they like. It has to be negotiated by the government. There are other provisions in the Farmers Variety Act. Though I would request Dr. Gangwar to share the meeting with the students. I mentioned the specific sections with every point. I would request you to jump to the second last slide. There was a talk of Biological Diversity Act. I think it has been discussed in detail by Dr. Vivek. Lastly, Copyright Act 1957. All of you are scientists, and there were questions regarding that whether we can publish the paper post filing of a patent application. Copyright protects, as Dr. Michelle was pointing out, the copyright protects the expressions, not the ideas. Right? So your original expressions are copyrighted. Originality means two things. Now, after the decision of the Supreme Court in Eastern Book Company versus Daily Modern, that it must be an independent creation. One, independent creation that it must be your own. It must not have been copied from another's expression. And secondly, there must be a modicum of creativity in your work. modicum of creativity is reflected by the scale and judgment of thought. So mere independent creation would not suffice now. It must be more than merely being independently created. But that does not mean the same thing. It does not mean that your expression has to be a new expression. New is an absolute term. New means, relatively speaking, at this point of time, this material never existed. Right? Absolutely new. Original is sufficiently original in the sense that this expression has been independently created, that is not being copied, and with the exercise of a minimum degree of creativity. That is a skill. Secondly, there must be human authorship with the advent of AI, ChatGPT and all. This question, whether a work created by an AI is protectable under the copyright. My take on that would be that as per the definition of author, when a work is being generated by the computer, the person who causes that work to be generated would be wrong. So the situations that can arise is that a person is using an AI as a tool to create an expression. Right? Just like a paint and a brush by a painter, or a pen and a paper by a writer. If the interference of that technology is as a tool, then that author can have a copyright over that. If there is a circumstance when AI has also an intellectual contribution in the form of originality, then they can be co-inventors. But if human intervention is totally absent, so for example, the person is just switching on the machine and switching off the machine, with no intellectual contribution going in order to prompt that AI to create something, then there is no human authorship involved. AI standing alone cannot be the copyright because there is a requirement of human authorship. Example, आपने monkey selfie case, if you must have heard of it. A monkey snatched a camera, but camera लेके भाग गया पुलिस. पेड़ पर चढ़ गया और गलती accidentally he clicked his own selfie. Question was, who would have a copyright upon that selfie? The camera owner, monkey, or PETA, the Organization for Welfare of Animals. Because PETA finally is the PO on behalf of monkey. Who should own it? If I ask you, when I say the rule is that there must be human authorship. Is it the camera owner? Is it the monkey? Is it PETA? Or no one? The answer to that would be no. Camera owner doesn't own that intangible. Camera owner may own the tangible. Monkey can't own it because there is no human author. AI cannot be an author because AI is not human. Right? PETA can't own it because monkey can't own it. So no one would have copyright, right? But the right to property in its tangible form would be of the camera. So another issue, there's one more issue. I'll just take 2 more minutes. Is with regard to biotechnology innovation. So there is a chimera. That is, when a human element has been used in conjunction with, let's say, an animal. So microorganism is created with some components which are human and some components which are animal. It is new, it is not obvious, it is useful too. However, is it patentable or not? This is with regard to the question. The bar on patentability of humans is on the basis of morality. Now, if it is animal plus human, would morality clause apply to it? And this happens in a human rescue application in US. वहाँ पे एक टेस्ट एप्लीकेशन फाइल की गई कैमरा के ऊपर. Problem that arose was that how to define human. Whether it's the intellectual boundaries that define human, or whether it's the physical abilities that define. This question has been dealt differently in different jurisdictions. Europe would incline in declining a patent to such a time when US traditionally would be inclined to grant a patent to such a time when. Right? As far as India is concerned, my opinion is that it would be declined on the basis of the morality. I'm not going into why of this question, but you must remember this, that morality is a temporal-spatial concept. Morality standard changes with the time and space you are speaking in. Standards of America in granting a patent upon the same are not at the same time the standards in India here. And the standards in India might not remain the same in next century to come. So what might not be patentable today can be patentable tomorrow. Because of objections of morality might be different. So these are some of the points for you to think upon. This is the last slide. If you had any question in future which I can be helpful with, I'll given my email ID. You can contact me on that. If you had any question right now, you can ask me. Okay, thank you very much.
Thank you very much, sir, for sharing your profound knowledge with us. I would like to invite Dr. L.S. Gangwar, Principal Scientist in charge ITMU, to brief us about the topic in implementation of Access&Benefit sharing in agriculture research. Please welcome to the sir with a big round of applause.
Thank you. Honorable Chief Guest, Dr. J.P. Mishra, sir, all the other speakers. So now this is a very tough time for me to defend my topic, how to proceed, because most of the things have been covered. So I will try to finish it within a few minutes. Next, please. So as far as this outline of this subject is, I have to cover with this Indian IPR laws. I think most of the things have been covered. And another thing is PPVFRA and its registration of the variety that I would like to try to do that. And National Biodiversity Act have already been covered. So I will give some points on that one. And then this NIGOA protocol and this EBS regulations. What are the NIGOA protocol and what we have to do for this benefit sharing, that is assess and its benefit sharing with the community from where we have got this done clause. And then technology commercialization and benefit sharing in the ICR. So how in ICR में हम लोग किस तरह से उसको शेयर कर सकते हैं या कहना चाहिए हमारे क्लाइंटल्स हैं उनके लिए और उनपे मतलब टेक होम मैसेज मतलब कि मैसेज क्या है कि मतलब इससे क्या हमें इसमें प्रिकॉशंस रखने हैं. नेक्स्ट प्लीज. तो ये आईपीआर लॉज है जो नेक्स्ट प्लीज, ये तो सारे कुछ डिस्कस हो चुके हैं. और हमारी जो इंडिया में मतलब एक तरह से देश में क्या है कि हमें बैलेंसिंग रखनी होती है एक्ट, बैलेंसिंग एक्ट engaging this multiple stakeholders, क्योंकि इंडिया जैसे बहुत सारे जैसे चाहे WTO हो चाहे आपका ट्रिप्स हो और भी जो इंटरनेशनल ट्रीटीज है इंडिया मतलब बहुत सालों के सिग्नेचरी हैं, तो हमें उनको भी सबको एक तरह से कंप्लाइन करना, उनको ओबे करना है. और डिफरेंट हमारे सेटअप है कि जिसमें हमारा सीड से लेकर के आगे अल्टीमेट हमारा गोल है कि जो फूड सिक्योरिटी है वो हमारी कहीं कंप्रोमाइज ना हो. तो एक डिफरेंट लॉज जो ट्रीटीज है उनको भी हमें बैलेंस रखना है, उनको भी मतलब उनका मान और सम्मान रखना है, और साथ ही साथ में हमारे जो फार्मर्स हैं, चाहे हमारे वो रिसर्चर्स हैं या ब्रीडर्स हैं, उनके भी जो मतलब हक या राइट्स हैं वो भी प्रोटेक्ट होते रहे, और साथ साथ में हमारी जो फूड सिक्योरिटी, हमारे जो नेशनल ऑब्जेक्टिव है वो किसी तरह से मतलब उनको कॉम्प्रोमाइज ना करना पड़े। नेक्स्ट प्लीज। तो जहाँ तक इंडिया एक मैंने बताया कि सिग्नेचरी है मतलब डिफरेंट ऑर्गेनाइजेशन, चाहे वो WTO हो या ट्रिप्स हो, और इसके डिफरेंट आर्टिकल्स हैं एग्रीमेंट के, कि जिसमें कि हम पेटेंट कर सकते हैं, और इधर ये इफेक्टिव जिसकी एक तो पेटेंट ले सकते हैं अपनी ब्रांड वैरायटी, उसके लिए सिनेर्जिक सिस्टम उसके बारे में रक्षा बताया, और या इनका कॉम्बिनेशन है कोई और डिफरेंट इसका एक बीच का रास्ता भी हो सकता है। नेक्स्ट प्लीज। तो जो फार्मर बीबी में हमारे 2001 हमें क्या कहते हैं कि देयर इज रिसर्चर्स राइट, रिसर्चर्स के अपने मतलब जो साइंटिस्ट हैं उनके कुछ अधिकार हैं मतलब, और जो हमारे ब्रीडर्स हैं उनके भी अधिकार हैं, और साथ ही साथ में हमारे जो फार्मर्स हैं उनके भी अधिकार हैं मतलब जो उनके जो इस एक्ट के तहत उनको दिए गए हैं। नेक्स्ट प्लीज। तो अगर हम डिफाइन करते हैं कि ब्रीडर कौन है और फार्मर्स कौन है, जैसे अभी बहुत सारे लेक्चर में सर ने बताया कि जो ब्रीडर एक वो होता है कि जिसने जो है उस वैरायटी को ब्रीड किया, उसको इवॉल्व किया, या फिर उस वैरायटी को डेवलप किया। तो ऐसा नहीं कि फार्मर्स हमारे जो किसान भाई है वो भी जो ट्रेडिशनल नॉलेज है, जो हमारी ऑलरेडी पब्लिक डोमेन से वैरायटी है, अब उनको उन्होंने कंजर्व किया जनरेशन टू जनरेशन, तो वो भी एक तरह से उसको उन्होंने कल्टीवेट किया, उसको एक तरह से संरक्षित रखा है डिफरेंट फॉर्म्स में, उसके सीड के फॉर्म में, और उसको एक तरह से बहुत सारे ऐसे भी किसान हैं जो कि उसको इनोवेटिव, जो उसको और फर्दर उसको अच्छा करने के उसको ब्रीड भी किया है। तो एक तरह से डेफिनेशन मतलब ब्रीडर और किसान एक तरह से ओवरलैपिंग डेफिनेशन है। नेक्स्ट प्लीज। तो ब्रीडर्स के क्या राइट होते हैं कि मतलब जो हमारे IPR में ब्रीडर्स के राइट हमारे तो फॉर प्रोटेक्शन ऑफ द प्लांट वैरायटी, तो एक तो स्टेटमेंट लाइन है जो कि इस एक्ट के हमें सेक्शन 28(1) में दी गए हैं। तो उसमें राइट क्या क्या है, वो उसको प्रोड्यूस कर सकते हैं, ब्रीडर उसको प्रोड्यूस कर सकते हैं, उसको सेल कर सकते हैं, उसकी मार्केटिंग कर सकते हैं, और उसको डिस्ट्रीब्यूशन भी हम लोग कर सकते हैं, एक्सपोर्ट इंपोर्ट भी कर सकते हैं, जो भी हमारा जेनेटिक मटेरियल। नेक्स्ट प्लीज। इसी तरह से रिसर्चर्स के कुछ राइट है, रिसर्चर उसको किसी का अपनी इस कोई भी रजिस्टर्ड वैरायटी है उसके लिए अपना एक्सपेरिमेंटल और रिसर्च पर्पस के लिए उसको यूज कर सकते हैं, और वैरायटी को एज एन इनिशियल सोर्स ऑफ वैरायटी दे कैन फॉर अदर वैरायटी डेवलपमेंट के लिए हम इसको यूज कर सकते हैं, और इसमें एक ऑथेंटिकेशन ऑफ द वैरायटी रजिस्टर्ड जो है उसको एक रेपुटेड यूज के लिए भी मतलब उसको रिक्वायरमेंट के लिए उसको यूज कर सकते हैं, उसको दे सकते हैं। नेक्स्ट प्लीज। इसी तरह से किसानों के बहुत सारे जो राइट्स है वो सेक्शन 39 में दिए हुए हैं, तो फार्मर्स में मतलब जो राइट्स है उसको अपना यूज कर सकते हैं, उसका प्रोटेक्शन फ्रॉम जो कहते फार्मर्स के क्लेम कंपनसेशन, अगर कहीं कोई उनकी वैरायटी को जो इलीगल तरीके से यूज किया तो उसका भी क्लेम कर सकते हैं। तो डिफरेंट इसके फार्मर्स के भी अपने राइट्स है जो कि इसी इलाके के अंतर्गत सेक्शन 39 में डिफाइंड है। नेक्स्ट प्लीज। तो जैसे कि कोई वैरायटी हमने मतलब रजिस्टर करनी तो उसके लिए डिफरेंट उसका फीस का प्रोविजन है, और फीस का प्रोविजन क्या करें, कोई नोटिफाई वैरायटी तो उसको हमें मतलब जो है एफआरए के लिए एक फीस जमा करनी होती है अंडर सेक्शन 5 ऑफ सीड एक्ट, तो उसमें 2000 रुपए जो नोटिफाइड वैरायटी उसके लिए है, और कोई न्यू वैरायटी है तो उसके लिए भी 2000 रुपीज प्लस 0.2% ऑफ सेल वैल्यू जो भी है मतलब वो उसको डिफाइन करना है, वो उसको करना है, और डबल एक्सटेंड वैरायटी है उसके लिए भी सेम फीस है, प्लस अगर उसका वो कोई कमर्शियल यूज करते हैं तो उसके लिए भी वैरायटी पूरी मतलब उसको शेयर करनी होती है, और जो फार्मर्स वैरायटी है उसके लिए मतलब एक तरह से एग्जाम्पशन है, खाली 10 रुपए देकर 10 रुपए के बाद भी वो अपना उसको कर सकते हैं। तो ये एनुअल फी, और साथ ही साथ में उसको रिन्यूअल भी कराना पड़ता है, जैसे कि जो ब्रांड वैरायटी का डिफरेंट पीरियड है उसके बाद में उसका रिन्यूअल करना होता है। नेक्स्ट प्लीज। तो ये फार्मर्स राइट को कोई डिस्टेंस है मतलब एक तरह से काफी डिटेल्स इसके बारे में सर ने बता ही चुके हैं मतलब डॉक्टर विकास भाटी सर। नेक्स्ट प्लीज। तो ये हमारे की जो डोमेस्टिक जो सीड इंडस्ट्री है तो उसमें कोई मतलब किसान और कहना चाहिए जो ब्रीडर्स और उनके जो वाइलर्स है उसके मतलब कोई ऐसी टैक्सेल नहीं है कि जो इसके लिए कोई कोर्ट और उसकी कचहरी की जरूरत हो, और जो फ्यूचर में मतलब जो उसका एक ग्रोथ है, चाहे वो हमारा ग्लोबल मार्केट हो या कहना चाहिए इंडियन वैल्यू में मतलब इसकी फ्यूचर में सीड इंडस्ट्री की काफी ग्रोथ की पॉसिबिलिटी है, मगर उसके लिए हमें अपने जो वाइलर्स है उसके लिए एक तरह से उनको कंबाइन करना होगा। नेक्स्ट प्लीज। तो बायोलॉजिकल डाइवर्सिटी एक्ट के बारे में डॉक्टर ने काफी कुछ बता दिया, डिफरेंट प्रोविजन इसके हैं, उसको डिटेल में नहीं जाएंगे, ऑलरेडी डिस्कस हो चुके हैं। नेक्स्ट प्लीज। तो कुछ साइलेंट फीचर्स इसके क्या क्या है कि मतलब रेगुलेट एसेस टू द बायोलॉजिकल रिसोर्स इन द कंट्री, हमारे देश में जो भी हमारी जैविक विविधता है उसको हम रेगुलेट कर सकते हैं, उसके लिए कैसे एसेस करना है, और कंजर्वेशन और उसका सस्टेनेबल यूज भी कैसे करना है बायोडायवर्सिटी का, और टू रेस्पेक्ट द नॉलेज, प्रोटेक्ट नॉलेज ऑफ द लोकल बॉडीज। बहुत सारी मतलब आईटी केस है हमारी, बहुत सारी मतलब वेराइटीज है, बहुत सारी और भी ट्रेडिशनल मतलब जो परंपरागत नॉलेज है उसको भी इसके तहत हम कैसे से प्रोटेक्ट कर सकते हैं। तो इसका जो बहुत सारे प्रोविजंस ये बायोडायवर्सिटी एक्ट में दिए गए हैं। नेक्स्ट प्लीज। तो बायोडायवर्सिटी एक्ट में क्या कर सकते हैं, कंजर्वेशन ऑफ बायोलॉजिकल रिसोर्स को मतलब कंजर्व कर सकते हैं, मैनेज कर सकते हैं, एंड इट्स सस्टेनेबल यूज एंड अनेबल द फेयर एंड इक्विटेबल शेयर ऑफ द बेनिफिट। तो यहाँ पर बेनिफिट शेयर की बात आती है, और इसी के तहत जो बायोडायवर्सिटी एक्ट 2002 है उसके तहत ही मतलब नेशनल बायोडायवर्सिटी अथॉरिटी का मतलब क्रिएशन किया गया, जिससे कि मतलब ग्रांट अप्रूवल फॉर द undertaking any activity referred to section 3, 4 and 5। तो ये डिफरेंट इसके सेक्शन से इसमें क्या क्या मतलब प्रोविजंस है। नेक्स्ट प्लीज। तो स्ट्रक्चर में पता ही देता है बायोडायवर्सिटी का नेशनल लेवल पे हमारा एक नेशनल बायोडायवर्सिटी अथॉरिटी जिसका हेडक्वार्टर चेन्नई में है। बाकी हम समझते हैं कि हम लोग सारे स्टेट में स्टेट डायवर्सिटी बोर्ड्स हैं, और बायोडायवर्सिटी मैनेजमेंट कमेटी तो विलेज लेवल पे है, करीब करीब ब्लॉक लेवल से भी छोटे स्तर पे कम से कम 2 या 4 एक ग्राम पंचायत के लेवल पर भी बायोडायवर्सिटी कमेटी बनी हुई है। तो उनका काम है कि हमारी जो जेनेटिक मटेरियल है जो हमारे, चाहे वो वैरायटी हो, एनिमल स्पीसीज हो, उसको कैसे डॉक्यूमेंट करना। तो एलिजिबिलिटी जैसे कि नई वैरायटी है तो उसको हमारे लिए क्या, इसमें भी डिस्कशन हो चुका है मतलब। तो उसमें नोबिलिटी होनी चाहिए, डिस्टिंक्टिवनेस होनी चाहिए, यूनिफॉर्मिटी होनी चाहिए, और कहना चाहिए आपका स्टेबिलिटी होनी चाहिए। तो इसमें जो नोबल क्या है कि मतलब एक नोबल इज द प्रोपोगेटिंग और हार्वेस्टिंग मटेरियल ऑफ द वैरायटी नॉट सोल्ड अदरवाइज। तो इसमें टाइमिंग अगर ट्री और हमारी वाइन्स है इसके लिए लेस देन 1 ईयर में इंडिया में जो है इसको एक तरह से हमें एक रजिस्ट्रेशन है उसको कहना चाहिए बीपीएफ वाले के साथ में उसका उसको वो करना होगा, अदरवाइज हम उसको मतलब बाद में फिर नहीं करा सकते। नेक्स्ट द ड्यूरेशन ऑफ प्रोटेक्शन डिफरेंट ट्री और वाइन्स और सबके अलग अलग प्रोटेक्शन है, और 18 इनिशियल जो प्लांट वैरायटी के लिए मतलब 15 से 20 साल का वो तय करना चाहिए पीरियड। तो 9 ईयर इनिशियल है, और उसके बाद फिर एक्सटेंडेबल अनदर फॉर 9 to 10 इयर्स। इसी तरह से अदर क्रॉप के लिए मिनिमम 15 इयर्स का डेट ऑफ फ्रॉम डेट ऑफ रजिस्ट्रेशन, जिस दिन से हमारा रजिस्ट्रेशन होता है। उसी तरह से जो एक्सटेंट वैरायटीज है उसके लिए भी मतलब 15 ईयर फॉर नोटिफाइड अंडर दिस सीड एक्ट 1966 में, और इसका ये प्रोविजन है। नेक्स्ट तो डिस्टिंक्शंस किसको कह सकते हैं, हमारी एप्पल का एग्जांपल लेते हैं, हमारी कितनी बायोडायवर्सिटी आप उसमें देख सकते हैं। नेक्स्ट प्लीज। इसी तरह से कि मतलब एक यूनिफॉर्मिटी, अगर आप फर्स्ट देखते हैं तो ये यूनिफॉर्म, सेकंड अगर ये अगर वो करेक्टर नहीं है, सेकंड में तो यूनिफॉर्मिटी नहीं है तो दैट कैन नॉट बी यूनिफॉर्म। नेक्स्ट प्लीज। सो स्टेबिलिटी कि अगर हमारा जनरेशन टू जनरेशन वो स्टेबल है, और सेकंड केस में मतलब अनस्टेबल है। नेक्स्ट प्लीज। तो एसेस और बेनिफिट शेयरिंग मतलब क्यों, और मतलब व्हाई, क्या हम उसमें शेयर कर सकते हैं और क्यों उसको हमें शेयर करने की जरूरत है। नेक्स्ट प्लीज। तो इसमें जो इंटेलेक्चुअल प्रॉपर्टी के बहुत सारे राइट्स जो कहना चाहिए गाइडलाइंस भी मतलब इशू है, मतलब पिछले 2006 से लेकर 2023 तक तो कई सारी बाइलाइज और इम्प्लीकेशंस ऑफ इंडियन न्यू लॉ रिजिम मतलब इन्होंने अडॉप्ट किया, एंड मैक्सिमम आईसीआर ड्रिवन अवेयरनेस प्रोग्राम जैसे कि हम क्या कर रहे हैं ऑन आईपी इश्यूज, और 3 गाइडलाइंस ऑन आईपी एंड रिलेटेड एस्पेक्ट पे मतलब कई सारी गाइडलाइंस पे मतलब आईसीआर ने या इसको लॉन्च किया है, एंड इम्प्लीमेंटेशन ऑफ नेशनल आईपीआर पॉलिसी आईसीआर ने इसको इम्प्लीमेंट किए हैं। और अभी मतलब जो रिसर्च में जैसे कि अटल एग्री इनोवेशन मिशन है, एग्री स्टार्टअप्स है, और भी बहुत सारी गवर्नमेंट की स्कीम है जो कि मतलब इन्होंने आईपी को प्रोटेक्ट करते हुए मतलब आईसीआर ने मतलब जो एग्रीकल्चर रिसर्च में उसको लॉन्च किया है। नेक्स्ट प्लीज। तो जहाँ तक डिफरेंट लेजिस्लेशन के बारे में है, ये डिफरेंट बात है, और क्या क्या इसके मतलब जो निकोबार प्रोटोकॉल 2010 में साइन हुआ था, और इसी तरह से मतलब बायो रिसोर्सेज बायो रेस्टल डायरेक्टिव का भी है। कई सारे लॉज हैं जो कि इसमें एसेस एंड बेनिफिट शेयरिंग यूएस गाइडेंस आईसीआर 2014 में मतलब इसको पहले फॉर्मुलेट करता, and again they have revised in 2020 मतलब 2020 में इसको रिवाइज किया गया है और मोस्ट ऑफ कुछ जो पॉइंट्स थे उसको उन्होंने फर्दर उसको शेयरिंग के लिए कैसे इम्प्लीमेंट करना है वो इन्होंने इसमें डिफाइन किया है। नेक्स्ट प्लीज। तो रेलेवेंस ऑफ बायोलॉजिकल में आई थिंक ये भी काफी कुछ डिस्कस हो चुका है। क्या है कि बायोलॉजिकल तो बायोलॉजिकल रिसोर्सेज है मतलब इसमें बायोलॉजिकल रिसोर्स हमारे प्लांट्स भी हो सकते हैं, एनिमल्स भी हो सकते हैं और माइक्रो ऑर्गेनिज्म भी हो सकते हैं। इसी तरह से बायो इनका बायो सर्वे एंड बायो यूटिलाइजेशन इसको किस तरह से हमें अपना सस्टेनेबल यूज के लिए करना है और बेनिफिट क्लेम मतलब जैसे कोई बेनिफिट्स है अगर इकोनॉमिक बेनिफिट्स है तो क्लेमेंट्स बहुत सारे हो सकते हैं तो उसको किस तरह से जो वो जो काम है जैसे एक कोई वैरायटी है मान लीजिए जैसे कि सावा मसूरी का ही केस है तो मतलब वो आंध्र प्रदेश कहता है कि दिस वाज रियली इन द बिगिनिंग वाज आवर वैरायटी, कर्नाटक वो कहते हैं कि हमारी वैरायटी था और तेलंगाना से और वैरायटी। तो बहुत सारे डिस्प्यूट है कि मतलब नंबर ऑफ क्लेमेंट्स ऑफ ए पर्टिकुलर जानवर तो वो एक तरह से आपका जो स्टेट बायोडायवर्सिटी बोर्ड है वो अपने केस को प्रेजेंट करके ऑन द बेसिस ऑफ जो हमारी बायो मैनेजमेंट कमेटी है उनके जो फैक्ट एंड फिगर्स को लेकर के उन्होंने रजिस्टर बनाए हुए मतलब उनका डॉक्यूमेंटेशन है उसके बाद में उसकी जो फाइनल डिसीजन अथॉरिटी होगी वो नेशनल बायोडायवर्सिटी जो अथॉरिटी है मतलब उनकी जो चेयरमैन है वो उसको डिसाइड करेंगे कि मतलब किसका क्लेम अगर भाई ये होता है कि ज्यूडिकेशन में अगर ये क्लेम सही पाई जाती है तीनों की तो उनको एक शेयर कितना शेयर किस इंस्टीट्यूट को दिया जाए किसको मतलब वो डिसाइड करने का काम जो है बायोडायवर्सिटी अथॉरिटी का रहता है। और कमर्शियल यूटिलाइजेशन के लिए मतलब अगर हम उसको यूज करते हैं तो बायोलॉजिकल रिसोर्सेज को मतलब वो भी मतलब जो है इसमें इसी के बायोडायवर्सिटी एक्ट के तहत आता है। नेक्स्ट प्लीज। तो बायोडायवर्सिटी अथॉरिटी का मतलब ये एस्टैब्लिश मतलब नेशनल बायोडायवर्सिटी अथॉरिटी 2003 में मतलब जो नेशनल बायोडायवर्सिटी अथॉरिटी वो 2003 में मतलब एस्टैब्लिश किया गया था ऑन द बेसिस ऑफ दिस बायोडायवर्सिटी एक्ट 2002 के उसमें और ये स्टेटरी बॉडी है और इसका मतलब हेडक्वार्टर चेन्नई में है। एस्टैब्लिश्ड इन एस्टैब्लिश्ड एनआईएफ सपोर्टेड क्रिएशन ऑफ स्टेट डायवर्सिटी बोर्ड इन आई थिंक आर स्टेट 29 आर स्टेट and they have facilitated establishment more than 2.7 lakh this bio BMCs or maybe the latest figure may be nearly 2.9 or maybe 3 lakh BMCs. Next please. The functions different functions भी मतलब किसके क्या क्या फंक्शन है इसके तो रेगुलेटरी फंक्शन से फैसिलिटेट फंक्शन से और फिर एडवाइजरी फंक्शन है मतलब तो ये बायोडायवर्सिटी अथॉरिटी के फंक्शन है facilitated regulatory as well as advisory functions. Next please. तो स्टेट बायोडायवर्सिटी के भी अपने रूल्स है उसको भी नेक्स्ट प्लीज। इसी तरह से इसके फंक्शंस है मतलब फंक्शंस में इसका एक तो एडवाइजरी फंक्शंस है रेगुलेटरी फंक्शन और फिर परफॉर्मर वो भी फंक्शन है। नेक्स्ट प्लीज। तो बायोडायवर्सिटी मैनेजमेंट कमेटी इनके भी अपने फंक्शन है एवरी लोकल बॉडी sir constitute a biodiversity management committee within its area for the purpose of promoting conservation of the these biodiversity resource, their sustainable use, or national biodiversity authority and instead consult this BMC committee while taking a decision related to the biological resource and its traditional knowledge, the use of traditional knowledge. तो जो एरिया की जो बीएमसी से वो कंसल्टेशन करके उसको शेयर करना है रिसर्च पर्पस के लिए या मतलब कमर्शियल पर्पस के लिए ये बीएमसी के फंक्शन से मतलब प्रमोटिंग कंजर्वेशन का मेन फंक्शन है। देन मे बी चार्जेस अगर कोई बायोडायवर्सिटी को यूज करते हैं तो उसको अपना चार्जेस लगा सकते हैं एंड टू प्रिपेयर पीपल्स बायोडायवर्सिटी रजिस्टर मतलब उसको इन कंसल्टेशन विद द लोकल पीपल क्योंकि बहुत सारे जो हमारे पूर्वज होते हैं जो कहना चाहिए सीनियर लोग हैं जिन्होंने कि उसको काफी समय से उस नॉलेज को संजो के रखा है या उसके बारे में जानते हैं तो क्योंकि वो एक सर्टेन टाइम के बाद तो मतलब उसको फिर वो ट्रेडिशनल नॉलेज को उससे रजिस्टर के फॉर्म उसको डॉक्यूमेंट करना वो भी एक तरह से बीएमसी का एक फंक्शन है एंड मेंटेन द रजिस्टर अबाउट द डिटेल्स ऑन द बायो रिसोर्सेज कि हम कल को अगर कोई इससे पूछे कि भाई ये आप कैसे कर सकते हो कि आप ही का रिसोर्स है तो उसको में प्रॉपर डॉक्यूमेंटेशन की भी काम है वो बीएमसी का एक मेन फंक्शन है। नेक्स्ट प्लीज। तो रेगुलेशंस फॉर टू एसेस बायोलॉजिकल रिसोर्सेज तो इसमें मतलब ये जो रूल्स है मतलब वो आपका एनबीए का काम रहता है, मतलब वो रहता है a person who is not इंडियन सिटीजन, तो उनके लिए जो ये एसेस और उसके शेयरिंग का है, तो उनके लिए मतलब आपको एक जो उनसे परमिशन मस्ट है, मतलब कि आप कोई जन प्लान किसी दूसरे कंट्री को या उसको या किसी इंडियन एनआरआई को देते हैं, तो एनबीए की परमिशन जो है वो कंपलसरी होती है एक तरह से। So the Nagoya Protocol on ABS, this is the World Summit on Sustainable Development. Johannesburg में ये सितंबर 2002 में शायद हुआ था, काली negotiation for an international within the framework of for conservation and safeguard of their fair and equitable sharing of the benefit in the international regime on the assets and benefit sharing. तो सेवेंथ कॉन्फ्रेंस जो पार्टीज 2004 में होता उसपे मतलब and then 10th convention of parties on 29th October 2010 at Nigoya, it was signed this that is known as the Nigoya Protocol on ABS. Next please. So what is Nigoya Protocol? It is a new international treaty on ABS to support the implementation and implement the objective of the CBD for this convention on biodiversity. This is the fair and equitable sharing of the benefits from the utilization of the genetic resources. Genetic resources are probably different for improvements and another thing is the landmark agreement in the international governance of the biodiversity for commercial and non-commercial sector. Dealing with the genetic resources. So, why the Goa protocol is important? इसकी क्यों importance है? क्योंकि we create the greater legal certainty इसके through and help in ensure the benefit sharing and then establish a more predictable condition for the access of the biological resources and encourage the advancement of research on genetic resources and create the incentive to create some incentive to conserve and sustainable the use of genetic resources. Because in the beginning, I think some speakers say that if the scientists or innovators or even conservators do not have any incentive, who will conserve? Why will they will conserve? So there should be give some incentive to these and enhance the contribution of biodiversity to develop the human society. Next, please. So why what does the Nagoya protocol covers? इसमें तो genetic resources and traditional knowledge को associate with the genetic resources as well as the benefits arising out of the its utilization. तो हमको इसमें शेयर करना है. तो जो benefit शेयर का और mutually agreed terms and condition जो ABS regulations हैं उसके अनुसार अगर commercial utilization of किसी तो sharing इस basis पे होती है कि अगर for a product developed of those genetic resources और अगर वो उसका 1 करोड़ रुपए तक का बिजनेस है अगर उन्होंने एक फाइनेंशियल में किया है तो they have to give nearly 1% as a share to the this NBA National Biodiversity Authority for its sharing. If your business is 1 to 3 crore rupees, that is 0.2% of the total business, and above 3 crore rupees is 0.3 to 0.5% of the total this revenue generated. It should go to the National Biodiversity Authority, and they will give it the benefits will be shared with the different stakeholders. Then transfer of research results, then benefit sharing obligation, that is 3.3 to 5% of the monetary consideration, and the IP rights. If applicants himself commercialize the process, meaning just like if you are in ICR, if we have commercialized by its own, so it will depend on 0.2 to 0.1% of the annual taxation plus government taxes, mostly the GST. So these are the and if it is the applicant assigning license, the process of product is commercialization to some you can say intermediate or you can say some just like in I said agri-innovate, it will be from 3 to 5% up to the front fee plus 2 to 5% of the received royalty plus applicable taxes. So these are the some obligations for sharing the benefit. So assess obligations over the domestic level. This is it should be create the condition to promote and encourage the conservation in research and biodiversity conservation sustainability with due regard to the to cases of urgent and immediate, then consider the importance of genetic resources for food as well as for agriculture and its with special relevance in case of food security. Next, please. Next. So this is the global. We consider this multi-benefit. This global multilateral benefit sharing mechanism. So there is some terms and conditions how to go for that one. Next, please. Next, compliance. I think all these things have been covered. So next, please. So access to ITK genetic resources that is also covered under this biodiversity benefits sharing obligations means they have the supporting mechanism to assess this implementation and capacity building based on the country's self-assessment and this awareness raising with these among the key stakeholders and technology transfer and it's including this biotechnological research and this target financial support for this for capacity building or other thing. We can go for this the financial mechanism for that the global environmental for this facility that can be used for its creating awareness among the farmers. So the procedure for obtaining the IPS, I think that we will discuss different mode of benefit sharing. So the applicant, in case of transfer of results of the research under this regulation of the NBS, such monetary and non-monetary benefits agreed between the NBA provide the case for this transboundary. This is NBA should 3 to 5% of its consideration. It is negotiated in the monetary benefits is negotiable between the different parties. So the procedure for transfer because this benefit they cannot be directly paid to the these individuals or the claimant. They will be paid through this NBA. So any person who intended to transfer the biological material under associated knowledge, which has been granted grant assets, so that can be guided through this NBA or through this Biodiversity Act 2004 for the transfer of the such material to the third party. Next. So this scope of the biodiversity that are going to be discussed next please. So jurisdiction different next please. So the time framework for disposal of the application under this NBA. These are the different utilization next please. So how to file this different forms on e-filing next please. Requirement for NBA next I think. So procedure for application this is a different this is a set procedure through which we can so non next please. Next. Okay. So okay next please. Just last slide next last slide last previous slide last one that is how much previous one this one. I think sharing of the revenue for commercialization, particularly in ICR, there are two systems. Either we go for through our OS, another is this is commercialization through Agri Innovate Private Limited, that is a private entity in ICR for commercialization of the technology. And another thing is the commercialization of the directly to this entity. So if there is a different these things are already given in this ABS guidance 2020 how it can be shared and how much is the share for the different players. Next please. Next please. So the take home message is that the implementation of biodiversity other it should be to be strict for the welfare of the society and there is a need to follow the ethic as well as the code of conduct. And another thing is that the share of the vanity benefits and other claimants and a proper valuation of the potential technology to be offered and take help of the agri innovates for the typical things. And one last thing is that the violation of BDA is if you are transferring the genetic material to anybody. So this it is a punishable offense. Punishable as well as cognizable and non-punishable offense. So you should be very careful. That's a take-home message that before transferring our genetic material to somebody or some other person, you should be very careful. You should be follow the all rules and regulation of the NBA. Thank you very much. Anybody?
Thank you very much, sir, for sharing the knowledge with us. We are highly grateful to all our speakers for providing insights of intellectual property rights. I hope that all attendees will be highly benefited. Now, I would like to invite respected PC sir to present memento as a token of love and appreciation to our chief guest, Dr. J.P. Mishra, sir. Thank you very much, sir. I call upon respected PC sir to present memento as a token of love and appreciation to Dr. Vivek Srivastava.
फोटोग्राफर को दिक्कत
Thank you very much, sir. Once again, I request to PC sir to present memento as a token of love and appreciation to Dr. Sripati Rao Kulkarni, sir. Thank you very much, sir. I would like to request PC sir once again to present token of love and appreciation to Dr. Vikas Bhati, sir. Thank you very much, sir. Now I would like to request PC sir to present token of love and appreciation to Dr. L.S. Gangwar. Thank you very much, sir. Moving on, it's time to propose vote of thanks. Let me invite.
सम्मानित मंच डॉक्टर मिश्रा सर, डॉक्टर भाटी, डॉक्टर श्रीवास्तव एंड डॉक्टर कुलकर्णी, हमारे इस प्रोग्राम के कन्वीनर डॉक्टर गंगवार, पीएमई डॉक्टर शर्मा, हमारे वरिष्ठ बहुत सारे कलीग्स और हमारे एक बहुत बड़े गन्ना प्रदेश के जो है रिप्रेजेंटेटिव, हमारे ये महाराष्ट्र के किसान, एक बौद्धिक संपदा अधिकार की चर्चा हो रही थी और आपको समझने के लिए, हमारे किसान भाइयों को समझने के लिए, आपकी बुद्धि का जो धन है, संपदा माने धन, आपके बुद्धि का जो धन है उसका कानूनी अधिकार आपको कैसे मिले।
जैसे आप कोई नागपुर का किसान है, किसी संतरे से कोई खास प्रोडक्ट बनाता है, तो उसका अधिकार उसको मिलना चाहिए। अगर कहीं बाजार में वो चीज बेची जा रही है तो कुछ हिस्सा आपको, मान लीजिए आपके गांव में आपने कोई एक लोकल, आपने नृत्य का एक खोज किया, तो उसका भी अधिकार आपकी बुद्धिमत्ता का आपको मिलना चाहिए। और उसका कुछ कोई फिल्म इंडस्ट्री में अगर लेता है तो उससे आपको कुछ धन आपको मिलना चाहिए। बहुत चर्चा हो चुकी है, अब इस पे हम और समय नहीं लेंगे। धन्यवाद। ज्ञापन पे आते हैं। और हमारे जो ये वक्ता थे, ये निश्चित रूप से अपने इस बौद्धिक संपदा अधिकार के बहुत ज्ञानी लोग थे। और मिश्रा जी के टाइम में तो ये तब एक शेप ले रहा था, कुछ बहुत कानून और इस तरह की स्थिति ज्यादा थी नहीं जब उन्होंने अध्ययन किया और इसको समय के साथ कैसे क्रियान्वित किया गया है। तो आप लोग सुन चुके हैं। हाँ, थोड़ा सा मैं इस चीज का आपसे क्षमा चाहता हूँ हमारे किसान भाइयों से, कि थोड़ी हिंदी में अगर कुछ उसका अंश आपको बताया गया होता, लेकिन कोई बात नहीं, आपको उसका हिंदी अनुवाद करके बता दिया जाएगा। हमारे शर्मा जी इस चीज का ध्यान रखेंगे। बहुत बहुत धन्यवाद। आप सभी को नमस्कार, सादर प्रणाम।
आपके बहुमूल्य शब्दों के लिए बहुत बहुत धन्यवाद। अब मैं धन्यवाद ज्ञापन करने के लिए डॉक्टर A.K. शर्मा सर जी को बुलाना चाहती हूँ।
नमस्कार, गुड आफ्टरनून टू ऑल। जैसे कि आपको, आप सुबह से इस जो वर्कशॉप है उसमें पार्टिसिपेट कर रहे हैं, उसके लिए बहुत बहुत धन्यवाद। और इस कड़ी में मैं सबसे पहले धन्यवाद ज्ञापित करना चाहूंगा हमारे निदेशक महोदय, जिन्होंने अपने वैल्यू जो अपना बहुमूल्य समय था उसमें से थोड़ा टाइम निकाला और हमारे इस कार्यक्रम की शुरुआत की। क्योंकि ICR सिस्टम में हमारी जो इंस्टीट्यूट है वो इस साल जो है हमारे यहाँ पे भी जो है पढ़ाई का कार्यक्रम भी शुरू हुआ है। और ICR हब लखनऊ के नाम से यहाँ पे फर्स्ट बैच चल रहा है। उनके एग्जाम भी स्टार्ट हुए, तो कुछ स्टाफ हमारा वहाँ पे एंगेज है और स्टूडेंट्स भी हैं। तो जो मिड टर्म एग्जाम जो है वो आज से स्टार्ट हुए, 26 तक रहेंगे, तो इसलिए कुछ स्टाफ भी नहीं आ पाया। तो डॉक्टर साहब ने यहाँ पे आकर, डॉक्टर साहब जो है यहाँ पे आके हमें संबोधित किया और उन्होंने ICR के जो कंसर्न है वो हमें बताया। जो हमारी एक संस्था दिल्ली में है, मैं किसान भाइयों के लिए कह रहा हूँ कि जैसे कि हमारे परियोजना संबंध जी ने कहा कि जो हमारे जो हेड ऑफिस है वो दिल्ली में है, ICR, उसको हम ICR बोलते हैं। उसके जो कंसर्न है कि हमें कहा जाता है कि आपकी जो टेक्नोलॉजी बनाई है और किसानों को मुफ्त दीजिए, फ्री दीजिए, मगर एक तरफ हमारे साइंटिस्टों के ऊपर ये भी दबाव होता है कि आप उसको पेटेंट करवाइए। तो अब इस जो है जो दो इंटरेस्ट है जो आपस में मिलने के लिए बड़ा मुश्किल है। साइंटिस्टों के ऊपर दबाव है और ये भी दबाव है कि किसानों को मुफ्त देना है। तो इस विषय, इस समन्वय को करते हुए यहाँ पे एक गोष्ठी थी। उस गोष्ठी में हम लोगों ने अलग अलग जो गवर्नमेंट ने नियम बनाए हुए, जो कुछ जो पुराने नियम हैं और उनका समावेश करते हुए जो है हमारे जो अलग अलग वक्ता थे उसमें न्याय से जुड़े हुए थे। डॉक्टर साहब जो है, तो मैं जरा जैसे कि निवेदन हुआ मैं कट शॉर्ट करूंगा। तो हमारा पहला धन्यवाद जो है निदेशक महोदय के लिए। हम जो है डॉक्टर JP मिश्रा जी का जो है स्पेशल धन्यवाद जो है ज्ञापन करना चाहेंगे। डॉक्टर JP मिश्रा जी एक वो फादरली फिगर है हमारे लिए और वो उन्होंने डिफरेंट प्लेटफॉर्म पे काम किया। मैं थोड़ा सा जो है थोड़ा सा उनका बारे में बताना चाहूंगा। डॉक्टर कामनी ने बताया भी, मगर वो बैंक में AGM की पोस्ट पर गए हैं और उन्होंने कई लोगों को लोन दिया होगा जहां तक बैंकिंग का वो है। जो बैंक वाले हैं, चीफ जो मैनेजर टाइप के लोग जो है उनसे लेवल के उनको ट्रेनिंग दिया है। फिर उन्होंने स्टेट गवर्नमेंट में काम किया, एपीसी से और चीफ सेक्रेटरी के साथ कई गवर्नमेंट का इवैल्यूएशन किया, और उनकी रिकमेंडेशंस पे एक बार जब डॉक्टर साहब के साथ हमें काम करने का मौका मिला तो कुछ इतनी घपलाबाजी हुई थी जैसे जो हैंड पंप होते हैं, तो डॉक्टर साहब की एक स्टडी के बेसिस पे 48 लोगों की सस्पेंशन हुआ था। तो और भी हम पूरे यूपी के डिस्ट्रिक्ट लेवल का था। डॉक्टर साहब ने आईसीआर में ये आईपीआर जो बौद्धिक संपदा वाला जो डिपार्टमेंट है वो है, अलग अलग विभागों का कोऑर्डिनेशन का है, अंतरराष्ट्रीय स्तर पे कैसे रिलेशन है, इस टाइप से अलग अलग एस्पेक्ट पे काम किया। और डॉक्टर साहब एक गुरु की तरह है, जैसे एक टीचर है गुरु में है, टीचर और गुरु में क्या फर्क होता है। तो मैं थोड़ा सा इस मौके का मैं फायदा लेके बताना चाहूंगा कि टीचर होता है वो हमें नॉलेज देता है, वो हमें सब्जेक्ट पता नहीं है और वो एक नॉलेज हमें जो है ज्ञान देता है, मगर गुरु वो होता है उसी नॉलेज को एक टूल बनाता है और उस टूल से लेकर के आपके दिमाग में जो कचरा भरा हुआ है उसको साफ करता है कि क्या आपके लिए सही है क्या नहीं है। तो वो जो कचरा भरा हुआ है उसको भी साफ करने का काम करते हैं। तो डॉक्टर साहब तो इतनी फिगर है, तो डॉक्टर साहब हम आपके लिए तहे दिल से जो है आपका आभार व्यक्त करते हैं। मैं धन्यवाद ज्ञापित करना चाहूंगा हमारे जो वक्ता हैं आज के प्रेसिस वक्ता डॉक्टर विवेक श्रीवास्तव जी जो और डॉक्टर कुलकर्णी जी, ये हमारी CISR संस्थाएं हैं उनके रिप्रेजेंट करते हैं। और CISR संस्थाओं में जो IPR इश्यूज हैं, जो पेटेंट करवाने का काम है, ये काफी पहले से है और ये लोग काफी जो है आगे हैं, ICAR सिस्टम से काफी आगे हैं और इस चीज में इनको बहुत एम्फेसिस दिया जाता है। हमारा चूंकि हम एग्रीकल्चर से जुड़े हैं तो हमें जो एम्फेसिस आया वो बाद में आया, और हम लोग जो है हमारी जो अभी जो स्टेज है थोड़ी कम है। तो डॉक्टर साहब मैं आप लोगों का बहुत धन्यवाद करता हूँ कि आपने डॉक्टर विवेक श्रीवास्तव जी आपने जो चीजें बताई हमें, जैसे नीड वांट और डिमांड, बायोडायवर्सिटी रिलेटेड इश्यूज हैं, और जो फॉर्म 3 है उसके बारे में उसको जो है क्या उसकी इम्पोर्टेंस है, ये हमें सेंसिटाइज करने के लिए धन्यवाद। डॉक्टर श्रीमती राव कुलकर्णी जी, आपका आपने टेंजिबल इंटेंजिबल और कैसे जो है पेटेंट डॉक्यूमेंट्स की क्या रिक्वायरमेंट है, और आपने एक जो कहा कि हर एक टॉम एंड हैरी जो है पेटेंट नहीं कर सकता है, ये बहुत सही, ये बहुत बिल्कुल सच्ची बात है, क्योंकि हमें एम्फेसिस इसमें ये मिलता है कि कैसे हमें एक नई चीज देनी है अपनी बुद्धि से, जो बहुत ही जो है जो इंटेलेक्चुअल है या जैसे साइंटिस्ट जब इस बारे में सोचेगा तब जाकर के इस प्रोडक्ट की तरफ हम अग्रसर होंगे, चाहे वो रिसर्चर है चाहे वो पेटेंट लेने वाला इन्वेंटर्स। डॉक्टर विकास भारती के लिए स्पेशल थैंक्स। डॉक्टर विकास भारती को हम पहले भी सुन चुके हैं, उन्होंने हमारे संस्थान में पहले भी जो है वक्तव्य दिए हैं और IPR से रिलेटेड दिए हैं। डॉक्टर साहब आपने विस्तार में जो पेटेंट एक्ट के बारे में बताया, डिस्कवरी और इन्वेंशन में डिपॉजिटरी इश्यूज और PPVFRA और मॉरलिटी इश्यूज के ऊपर प्रकाश डाला, इसके लिए धन्यवाद। मैं थैंक्स करना चाहूंगा डॉक्टर गंगवार को जिन्होंने जो है रेगुलेशंस एंड बेनिफिट शेयर के बारे में बताया। धन्यवाद डॉक्टर साहब। और जो आपकी बेनिफिट शेयरिंग में जो नॉर्म्स हैं उसके लिए मैं धन्यवाद करना चाहूंगा अपने संस्थान के सभी जो पार्टिसिपेंट्स हैं, साइंटिस्ट हैं, हेड्स ऑफ डिविजन्स और स्टूडेंट्स, और जो हमारे अन्य स्टाफ है, रिसर्चर जो हैं, RA, SRF, YPs, उनके लिए, और जो यंग साइंटिस्ट हैं उनके लिए ज्यादा जरूरत है, क्योंकि हमें जो पेटेंट है उसको अपने सिस्टम में इंस्टीट्यूशनलाइज करना है, और इंस्टीट्यूशनलाइज करने का मतलब ये है कि हमें उसको एक व्यवस्था बनानी पड़ेगी। एक्ट आ गए, सब कुछ आ गया, मगर फिर भी हमारी जो प्रोग्रेस वैसे नहीं आ रही है, तो हमें उसके लिए व्यवस्था बनाने के लिए कि कैसे हमें किस लेवल से, अगर हमारी कोई प्रोडक्ट पाइपलाइन में है तो कितना पहले हमें वो पेटेंट करना है। तो ये यंग साइंटिस्ट और यंगर जनरेशन का जो है ना सहभागिता करी, आपका बहुत बहुत धन्यवाद, और उम्मीद है कि आप इसका जो है भरपूर फायदा उठाएंगे। मैं किसानों के लिए जो पुणे आत्मा से आए हैं, आत्मा का मैं धन्यवाद करता हूँ कि जिन्होंने आपको स्पॉन्सर किया, आप आए हैं इधर, आपका बहुत धन्यवाद। आपका हिंदी में भी आपको बताया जाएगा, क्योंकि फिलहाल हो सकता जो इंग्लिश में जो व्याख्यान हुआ है इसमें इतना बेनिफिट ना मिले, मगर अभी आपकी जो हमारे साथ जो आपकी इंटरेक्शन होंगी उसमें हमें जो भी डिस्कशन हुआ है उसके साथ इंटरेक्शन होंगी। मैं धन्यवाद करता हूँ UPCST को जिन्होंने हमें कुछ फिनेंशियल मदद करी इस वर्कशॉप को ऑर्गेनाइज करने के लिए, और मैं जो है अपने स्टाफ का, डॉक्टर पामनी का, जिन्होंने ये सारी तैयारी करी, हमारे जो फोटोग्राफर और प्रेस मीडिया के जो हैं अवधेश कुमार यादव और योगेश कुमार, ये हमारे अभिषेक हैं, ये सब प्रेस और मीडिया से भी हैं, और बिहाइंड द सीन सब जो टीम लगी हुई है सारा इस हॉल मैनेजमेंट में, इन सभी को बहुत बहुत धन्यवाद। अगर कोई छूट गया हो तो माफ करना, सभी को बहुत बहुत धन्यवाद।
Thank you very much, sir. Time to wrap up the program is approaching, but this doesn't mean the program is over. Rather, it just marks the start of a new period of goal. Once again, thank you to all of you. After the national anthem, you all are invited for a lunch at guest house. Please stand up for the national anthem. Thank you, Jai Hind. You all are invited for lunch at guest house, please.